there is any conflict in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflict so that this honorable court could hear these matters.
Thank you. The court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to matters. Court does call the case of the people of the state of Michigan versus Seth Priester.
Is here Richard McDuffie on this case in Copenhagen? Okay.
Yes. He's on this. And got it.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Seth Priester.
Good morning, Seth Priester.
I'm gonna go and start again. What
happened?
Are they okay back there? Okay, go ahead. And Mr. Priester, can you state your name again, please, sir?
Your Honor, Seth Priester.
Thank you. All right, what are we doing?
If we could call the codependent case, it's constitutional one to approach.
Sorry, Judge. I know. First case, I'm causing havoc already.
Your
Judge, my case is Devosier Henning. He's in custody.
got that? You got that one?
Yes.
Why do I have?
My voice.
Looking for somebody that I need to mute over there. I believe Mr. I'm looking for the codependent case.
This is the way to start.
Sorry, Judge.
Got it?
No.
Court also, where is he? Is he in
He's in custody.
with
Yes.
them?
Yes. And if the
You
court,
want me to call it without him coming out? Can we please? Because Miss Constantino has asked,
sorry.
irrespective of what we were actually doing today, could we have Mr. Hennings? Thank you, sir.
Judge, would the court mind if we approach in the interim, just to keep things going?
Oh, it's too late for keeping things going, but oh yeah, come on.
You in there?
Thank you, Judge.
That's.
Got it.
Wondering why.
Got it. Okay.
Court does call the case of the people versus Marcus Claiborne.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Tina Saxon on behalf of Mr. Claiborne, who's approaching.
Your name, sir?
Marcus Claiborne.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
During the matter, probable cause conference will be during August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Court does. Mr.
Mr. Goodell, you need to move so
Oh,
that.
sorry.
Thank you.
Short court calls the case people versus Sean Billadu.
Thank you.
And Edward Lucas on behalf of Sean Billadu.
Your name?
Sean Billadu?
All right. You're requesting an adjournment on this?
Yeah, I think we are close in with negotiations. I'm asking for at least a week or two.
August 7th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Aaron.
Court does call the case of people versus Gregory Bell. Really?
Kyle Burdell on behalf of Mr. Bell, who's approaching the podium. Mr. Bell, please introduce yourself to the court.
Good morning, Your Honor. Gregory Bell.
Your Honor, today's the date and time set for probable cause conference. The people did extend an offer. Mr. Bell would like some time to think about that and as well to complete the proper form.
August 7th, 2025, 9 a.m. Bond continued.
Thank you, Judge. And I'll come back to you.
Court calls case people versus Anthony Alfaro. Yes.
People.
Good morning, Your Honor. Zach Bonham on behalf of the defendant.
You're gonna need to.
Oh, I'm sorry. I forgot he was.
Yeah. Your name, sir?
Anthony Alfaro, Calles.
All right.
Good morning.
Good morning.
Yeah.
All right, what are we doing on this case?
Your Honor, we've had a conversation with the prosecutor's office. They've extended an offer, and I need some time to review that with my client. So we'd ask that we reset this to another date, and then after that, I'd like to address bond if I could.
Is it the order that was submitted to the court?
It was the proposed order, Your Honor.
All right, I'll have to hear argument on that. Pardon?
It's not.
Got it. All right, so you need an adjournment of this?
Yes, Your Honor.
Probable cause conference will be adjourned to, you want the 31st or the 7th since he's in custody?
I would take the 31st, Your Honor.
July 31st, 2025, 9 a.m. As to bond.
Thank you, Your Honor. My client's been in custody for over 30 days now. He had an outstanding warrant on a vehicle for a misdemeanor registration that's been resolved as a civil infraction at this point as of June 24th. He doesn't have any prior convictions for violent offenses. He had a strong work history of over 5 years as a manager at Los Amigos in Ann Arbor. He's most likely lost that employment now due to his detainment. His family needs his financial assistance. He has a very strong family relationship in the area. He's retained our office to represent him in this matter. Since he's been in custody, he's been enrolled in AA classes. He's working in the jail's kitchen. So we're asking that he be released on a bond. I would ask for a PR bond. I know the prosecutor's office in the proposed order I provided you, they would be requesting home confinement. I won't speak on her behalf, but that's something I know the prosecutor's office was asking for. If that's something that would persuade the court to allow him to be released, so be it. And any other conditions that the court would impose. If it was home confinement, we would just ask that he have the ability to travel for work purposes, school, medical appointments, etc.
Response.
Thank you, Your Honor. I did have a chance to speak with counsel as well and express my concerns on this case. As the court knows, the bond violation is the second case involving the OWI and some other issues. I don't have an issue with him being released to home confinement. I would request some form of alcohol testing, whether that's a sober link or scram tether, due to those circumstances and alcohol kind of being a theme throughout some of these cases.
So you're saying the drunk driving was a violation of his bond?
The case in its entirety was the violation. It occurred after his arraignment on the prior case.
That didn't answer my question.
I'm sorry, can you?
The 15th District Court case is the violation. For which one came first?
The 14D case came first, 25.
Thank you. That's what I needed. All right. Anything else on this?
No, Your Honor.
All right. I will grant the release on this. I'll give him a $15,000 personal recognizance bond. Defendant, prior to release, will be placed on a home confinement tether, as well as, what was the alleged BAC in his drunk driving case? See here. You can put it in.
Yeah.
He's not here. That will be well, let me do it this way. The GPS tether will be a home confinement tether, and you don't know the BAC.
Unfortunately, Your Honor, can I pull this up?
We'll just put him on a sober link then. Testing device. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Carlos Sell.
Kyle Brill on behalf of, but not with Carlos Sell. You understand that there is a violation. I have not been able to contact him. I do have a good number, but I've just not been able to reach him.
No.
Asking for a show cause at this time.
Well, he's showing up. The violation of court is he's showing up with cocaine now in his system. So a bench warrant will issue for defendant's failure to appear until we get him no bond.
Understood.
That will issue immediately.
Understood. What's the dollar amount, Your Honor?
Pardon?
What's the dollar amount?
No bond.
Oh, no bond. Oh, thank you. Understood.
So that would be at 0. Court does call the case Other People versus Robert Roulette.
Hey, here, Richard, McDuffie for the people on both nights.
Alex Warren Green on behalf of Ms. Gallant in the matter ending 5713.
Good morning, Your Honor. Judge Kilwall, Judge, I'm on 5612.
Robert Gallant, also known as Mac.
Thank you. All right, what are we doing?
Judge, we're working on a possible resolution in this matter. We've spoken to my client. We're asking for a 2-week adjournment.
I would join that request, Your Honor. I'm completing a green sheet right now.
One of these doesn't have a green form, I think. Mr. Killow. Probable cause conference will be adjourned to July 31st. Will that be enough time for you guys to get done what you've done?
I believe so, Your Honor.
July 31st, 2025, 9 a.m. Bound continue.
Thank you.
Thank you, Your Honor.
Court calls case People versus Michael Ware, 2 cases.
Thank you, Richard.
Ed Rodriguez on behalf of Michael Ware.
Stephanie Cannon on behalf of Mr. Ware as well, Your Honor.
I'm an 863. And I just talked to him on the phone. I understand he's late. I'd be asking if the court could pass it.
And I would ask as well, Your Honor.
Where is he?
He said he was 10 minutes away and that was about 5 minutes ago.
Call it up. Well, then, call it up in 5 minutes. We better be here. Now he's getting a warrant.
Thank you, Your Honor.
Court calls the case of the people versus Tubbs.
If you arrest me, nothing for the people.
See, and I didn't call it like I normally call it.
Morning. If I'm the only one here on 1038. Judge, I was.
Your name, sir?
Oh, I'm sorry.
Shaquille Tubbs. Is that how you say it, really? Okay, all right.
Judge, I saw Shaquille last night at jail. I told him I had just been appointed. It's my understanding Ken Overwater is trying to get this young man into a recovery court with Judge Kuhnke. We're working on that. I explained to him I would be asking for a 2-week adjournment.
You said he's in recovery court, or they're trying to get him
It's
in?
my understanding he was initially denied several months ago. They're retrying him, so it's going to take a little bit of time.
Hearing no objection, I'll adjourn this to August 7th, 2025, 9 a.m. Continue.
Thanks,
Thank you. Court calls case people versus Riel Boyd.
Ready, Your Honor.
Alexander on behalf of the people, Your Honor.
Jay Columbia, Ms. Riel Boyd.
Riel Boyd.
Judge, we're working on a resolution, possible resolution of this matter with the prosecutor. We're asking for a 2.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
And you gotta give me that countdown at 5. Court calls the case people versus Devontae Owens.
Good morning, Your Honor. If it please this honorable court, Brandon Bird on behalf of Devontae Owens. Mr. Owens, can you please state your full name for the record?
Devontae Lawan Owens.
Thank you. All right. Sir, what are you asking for?
Respectfully requesting adjournment, Your Honor. I was just appointed yesterday.
Yes, sir. Probable cause conference.
Sorry, I'll speak with Mr. Bird as well, but I have been speaking to the sheriff's department. I know there's been a lot of ongoing investigation that's still happening, as well as cell phone analysis. I know specifically with respect to Mr. Owens' phone, so I'll make sure that stuff is shared as fast as possible.
All right. Do you think you'd be able to get enough of that information at least to council by the 31st, or do we need to go out one more week?
If we could go one more week, that would be my preference.
Any objection, council?
No objection, Your Honor.
Probable cause conference, August 7th, 2025, 9 a.m. Continue. All right, thank you.
Thank you.
Yes, one. Court does call the case of the people versus Theophilus Smith.
Ooh. Thank you, thank you, thank you.
Yes.
Judge Simpson, I can speak.
It's your case.
Yes, I can tell you what happened. I've been in jail for 100.
Hold on. Theophilus.
We're ready in this matter, Honorable. I'm Brown Deputy Defender appearing with and on behalf of Mr. Smith, who appears by Zoom. Mr. Smith, could you state your name for the record?
Theophilus D'Angelo Smith.
All right, you're requesting a forensic evaluation?
Yes, I think this matter is still,
No, I can speak for my Lauren Brown. Please don't say that. Please don't say that. That's inside my intelligence. That's inside my intelligence. No. You ain't even advocate with me. I will speak on my own behalf. And then you can
I
tell
believe
me.
there's one that's pending already.
Your Honor, the last update I have from May is that he was found incompetent but restorable, and
Right.
today was it had been scheduled on the 31st to check in.
Come on, like,
And
come
we,
on.
So
Can I
has the
speak,
court,
please? Can I speak, please? Without
one
hitting
moment,
my case?
one moment, please.
I can easily, I don't want to have to do it, but just let me
It's already been
speak,
sent
please.
out for one.
You'll get a chance, but wait on just a minute so that we can make sure that what you say has meaning.
No.
Has the court
what do you mean
received an
when every
updated?
word I speak, that mean I
I
said
have
something
not.
wrong?
Mr. Smith, I'm not gonna try to talk over you.
Okay, go ahead.
I am not gonna try to talk over you. So if you want to keep doing that, then I'll just mute you. Have a seat. Let me. Okay. Or dance.
Please know that no, I need to speak. I don't got time to be. I speak for myself.
Okay, Mr. Smith. You need to have a seat and don't interrupt me.
So, Your Honor, has the court received an updated report with respect to Mr. Smith?
I have not.
We have nothing further to present at this time. Would request that this matter be adjourned so that we can get an updated report.
And on the new case, requesting a forensic.
Yes.
All right. So on both of these matters, the one is set for a competency review.
Right, exactly right. The other is just tagging along with it.
So the new one, I'll set a competency. We don't have a new report, but one is coming in soon. So why don't you give me 45 days? Well, let's just give me the 90 and then I'll adjourn this to October 23rd, 2025, 9 a.m. Mr. Smith, you're muted.
My life.
All right. Mr. Smith, what do you want to tell me? I'm going to give you 2 minutes to tell me what you want to tell me.
Me sleeping in the worst cell and radiation. Me can't lay down without men feasting over me when I wake up. I gotta pray hard. I gotta sing, and the Holy Ghost be in me. And they praying over me. They beat me. I'm just saying, an ends to a means. Like everything's been recorded. Everybody know everything. Simpson, please, Simpson, do America a great justice. Injustice anywhere is a threat to justice everywhere. Please,
okay.
I can tell you more. I can tell you names. I'm tired. I'm scared to tell everything while I'm in here. My family is scared for me life. No, just do the right thing. I just ask you. I believe you are a judge that speaks justice. I believe you will just come on, just do the right thing. And my Lord, I trust. Amen.
I've done the right thing. We'll see you at the next hearing date, okay? Thank you, Mr. Smith. You can mute again. On continue. Court recalls the case of the People versus Michael Ware.
People.
Stephanie Cannon on behalf of Mr. Ware as it relates to case number ending in 5134.
On behalf of Michael Ware.
Here?
He said he was in the parking lot here.
He said he's in the parking lot?
And so I'm looking.
Told me 10 minutes before.
I know.
We needed 13.
What?
We needed 13
13 what?
minutes. Right.
I have a progress report. I don't have a bond violation.
Yes, Your Honor, I have a progress report. I don't have a bond violation.
You guys are gonna try to stall. Bench warrant was issued for defendant's failure to appear, bond 10,000, cash surety. That warrant was issued immediately. They need to be here.
I understand, Your Honor. Your Honor, what was the bench warrant? Again, 10,000 cash shorted?
Yes, ma'am.
Thank you.
Court calls case People versus Haruska Dennis.
On behalf of the people. Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Haruska Dennis, and I'm appearing in case number ending in 1150.
And if it's a public defender, it's not a curious. Your Honor, on the other matter, Representative Sargent.
All right, what are we doing?
Your Honor, this is a date and time set for a PCC in this matter. We did receive a mitigation report, I believe, just a couple days ago that was just very recently submitted to the prosecution. Given that, we would ask for an additional PCC to have time to complete those negotiations.
And that's our request on our matter as well, Your Honor.
On 31st of the 7th.
Judge, I would ask for the 31st, given he's in custody.
Yes.
Second.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bonds will continue.
Okay, you're awesome. Thank you, Judge.
Court calls case for the People versus Tanya Hall.
Morning, Jacob, on behalf of Ms. Hall. Tanya, are you here? Judge, as you know, Ms. Hall is homeless. She's been staying at Delana Center. I went there. They would not tell me. They could not confirm she's there, but I know she's there. I left a note. I never did speak with her. Would the court be gracious enough to give me one more adjournment to find her? Apparently I left a note. Apparently she
I have
came.
a cocaine test, a test positive for cocaine, and then she missed. So I might under the circumstances, but I'm not going to at this point. I'm going to issue a bench warrant for failure to appear. Bond is setting amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you. Court does call the case People versus Mario Crawford.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps on behalf of Mr. Crawford. Can you please state your name for the record?
Mario Crawford, Your Honor. Thank you.
Your Honor, we'd respectfully requesting an adjournment. We believe we are close to a deal with the people, and we would just need a little bit more time.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus, is it Chantel Bray Page?
Thank you, for the people.
And greetings, Your Honor. Emmett Greenwood on behalf of the defendant. My client is in person.
Your name, sir?
Chancellor Burpage.
All right.
Yes, Your Honor. Prosecution has graciously provided me all the discovery, so we're respectfully asking that we have an in-person exam.
Later, we have it. Second.
Yes.
Discovery being complete, would people have their witnesses available? That would be the day, August 5th.
The Charvettes.
Preliminary examination, August 5th, 2025, 9 a.m. That is in person before
Judge Fleischer.
Judge Fleischer.
Okay, and that's what date was that again, Your Honor?
August 5th.
Yeah, that's no problem. And Your Honor, may I address Bond very briefly?
Very briefly.
Yes. My client has requested that he either stop having a drop or at least reduce the amount of drops. He hasn't tested positive or anything, but it's creating such a financial drain on him and his family that he doesn't know how he'll be able to complete all that.
What is his current schedule?
Every week at random.
Every week?
I just got a call every day and
Well, given what appears to be the drug in here and his drug of choice, weekly testing is an appropriate testing.
Would you
So
consider
motion
bi-weekly?
for-
Would you consider bi-weekly?
I will not. You can bring it up before Judge Fleischer after the exam.
And I got a court date on the 5th too, in Canton. I think it's
So
at
you
9
can't
o'clock.
do the 5th?
I would have to adjust it with them. This is more serious than the other stuff, so.
Pardon?
I said this court date is more serious than the other court date, so.
Well, Your Honor, if he has a conflict, maybe we can do another date. Because we're ready to go.
Would the people be ready on the 29th, a week from today?
I doubt it, Your Honor.
And the next date I have would be the 12th.
That's fine for defense.
August 12th, 2025, 9 a.m. It is also before Judge Fleischer.
All right, in person. Thank you so
Good there.
much. You all
All
take
right,
care.
thank you. Court does call the cases of the people versus Matthew Fonseca.
And Alex Warren Green on behalf of Mr. Fonseca. Mr. Fonseca, could you state your name for the court?
Matthew Lewis Fonseca.
Your Honor, today's date and time for probable cause conference. At this time, we're asking the court to adjourn these matters so that I can continue my negotiations.
Probable cause conference, without objection, July 31st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Deja Moore.
Christina Costantino appearing on behalf of Ms. Moore, who appears via Zoom. Ms. Moore, can you unmute, turn your camera on, and state your name for the court?
Deja Moore.
Thank you.
Judge, this is the date and time set for PCC. I believe discovery is complete, so we would be asking to have this matter set for an in-person preliminary examination.
People have their witnesses available the 5th.
Judge, I apologize. I have.
No, you don't.
I have.
No, you do, but you don't mean it.
I do, but
The 12th or the 29th?
the 12th would work wonderfully. Thank you, Judge.
Not a problem. Preliminary examination will be in person, August 12th, 2025, 9 a.m. That is before Judge Valwell. Bond will continue.
Thank you, Judge.
Thank you. Court calls case People versus Jonathan Hughes.
Public Defender Hannah Apple appearing on behalf of Mr. Hughes, sitting in for Attorney Ms. White. Your Honor, we're asking for an adjournment. Mr. Hughes has some other cases that are pending. We'd like to
Your
keep
name,
on
sir?
track.
Mr. Hughes.
This other matter was on August 7th.
Before whom?
Before Your Honor, for the PCC.
So he has another Pete.
PCC, yes, Your Honor.
I'll adjourn the probable cause conference August 7th, 2025, 9 a.m. Bond will continue.
Thank you.
Court calls case People versus Tyrone Smith, the fourth.
Alexander on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Tyrone Smith, also known as Tya Smith.
Tyrone Smith, the
Thank
fourth.
you.
Respectfully, we'd like to set this matter for exam, Your Honor.
Discovery is complete.
As far as I know, Your Honor.
People have their witnesses available the 5th. Preliminary examination in person, August 5th, 2025, 9 a.m. That's before Judge Fleischer. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls case People versus Savannah Crittenden.
Have a great day too.
You do the same.
Good morning, Your Honor. Robert Elman with it on behalf of Ms. Crittenden. Ms. Crittenden, can you please state your name for the record?
Savannah Crittenden.
You're requesting an adjournment. You were just recently appointed.
Yes, Your Honor, I was just appointed yesterday, so I don't have discovery yet on this matter. However, when appropriate, I would like to address bond.
Adjourn the matter July 31st, 2025, 9 a.m. Yes, that's the bond briefing.
Your Honor, it's my understanding that these alleged incidents allegedly took place at an extended stay hotel while Ms. Crittenden's apartment complex was under construction. She has before staying in that extended stay hotel, had not known, and I would argue still does not know, the alleged complaining witness in this case, has no reason to have contact with them. I'm still trying to determine whether the construction at her apartment complex is complete. But Your Honor, I think that given the circumstances, I'd be asking for a release on a PR bond with a DPS tether with potentially a no-go to that extended stay hotel.
Response.
Your Honor, we would ask that the bond continue as set until the next probable cause conference date. The defendant was under investigation for criminal sexual conduct with a minor. That investigation was furthered for other information to be obtained. Ms. Crittenden was advised not to have any contact with the minor or his father, although there was no bond condition. She immediately went back to the hotel, had contact with the minor and his father. The police had to be called. The police came out, instructed her not to have contact with the minor and his father. The police left the hotel and were dispatched back again. She was in contact with the minor and the father and making arrests, hence the stalking charges. So we would ask that the bond continue.
And Your Honor, if I may,
yes.
Again, I just want to make sure it's clear. The CSC allegations, it's the same complaining witness as in the stalking charge. And again,
I'm just gonna get that.
So I just want to make sure that was clear, Your Honor. And again, I don't believe she has any reason to have contact with them. And I think a GPS tether with a no-go.
But as I understand, she was told, she was under investigation for a CSC, told not to have any contact with this specific individual as well as his father.
And she denies those allegations, Your Honor.
Understood, but the allegation is that then the police were called back twice after she was informed of that, and that there were threats, which, as Ms. Reiser's indicating, have led to the stalking charge. I'm actually, given those allegations, surprised that her bond is set so low. Motion for bond reduction is denied.
Thank you, Your Honor. One more thing, Your Honor, I apologize. I was hopeful that Ms. Crittenden would be released and then we could have an afternoon spot on the 31st. I do have a conflict in the morning.
You can talk about this. Well, no, it's going to be in the morning.
Right. No.
Put it on the 7th.
That's what I'm asking for, Your Honor.
All right. Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Motion for bond reduction having been done.
Thank you, Your Honor.
Court does call the case of the people versus Kareem Davis.
Andrew Banish.
Attorney George Long, P79687, appearing on behalf of the defendant, Kareem Davis. Please state your name for the record.
Kareem Davis. Has a substitution been signed up?
Yes, Your Honor.
I haven't. I don't know. Was there a substitution?
I have not received a substitution just yet. Oh, he's got it in his hand.
Okay, what are we doing in this case?
Today's date is set for a probable cause conference today. I've just recently been retained, Your Honor. I have not had an opportunity to review discovery, request an adjournment,
All right, I'll need a green sheet from it.
and an order for discovery, if I may.
Pardon?
An order for discovery as well.
Why would you need that?
About discovery, I think typically, it'll come from the public defender's office, but of course, I'm happy to make sure Mr. Long gets everything.
Thank you.
That's my order. He's out of custody. Do you want the 31st or the 7th, sir?
31st.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continued. That's mine.
Thank you, Your Honor.
We'll need that sheet back. That's not the green sheet. Court does call the case of the people versus Adrian Harrison.
Good morning, Your Honor. Robert Elman with and on behalf of Mr. Harrison is approaching. Mr. Harrison, when you get to the podium, can you please state your name?
Adrian Harrison.
You're requesting an adjournment.
Yes, Your Honor, I've been in discussion with the people regarding a potential resolution. You should also have in your file there an order modifying Mr. Harrison's bond so that he can be released treatment. I have been in contact with Dawn Farms about securing Mr. Harrison treatment. They've informed me that they cannot start the process of onboarding him until his bond is modified to allow him to actually be released. So that is the purpose of the order.
I don't have a problem signing the order, but I would need that, an order to that effect, but I would need a condition that if he does not or leaves treatment, he is to report back to the Washington County Jail.
I'd be happy to prepare a new order, Your Honor, or if you,
I'm not signing this one.
okay. Can we pass that and I'll write that in?
Here. I don't care how he does it. What date did we want this moved to?
Then I'll leave that to you, I know.
Your Honor, can we do 3 weeks?
The 12th? Or the 14th, I'm sorry.
That would work for the people.
That works for me, Your Honor.
Probable cause conference will be during August 14th, 2025, 9 a.m. Bound continued. Thank you. Bond continued. I will sign the order allowing his release to inpatient.
Thank you, Your Honor.
Thank you. Court calls case people versus Stephen Wainwright.
This is a public defender, Hannah Apple, appearing on behalf of Mr. Wainwright. Mr. Wainwright, will you please state your name for the record?
Stefan Wainwright.
Thank you. Your Honor, I'm asking for an adjournment. We are having some conversations regarding negotiations, but additionally, we do not have the video discovery for the case, so we need an adjournment.
All right. So I'll need the green sheet.
Yes.
How much time did you need? Just one, the 31st will work for you?
Yeah, I believe so, Judge.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bound continue.
Thank you.
Thank you.
Mr. Can I approach?
Thank you. Case of the people versus Zdravko. Is it Kidanov?
All Brown Deputy Chief, written on behalf of Mr. Kitno. State your name for the record.
Zdravko Kitno.
Okay, so that's still.
All right, what are we doing?
There's a mitigation report that's outstanding. We probably need a 2-week adjournment to make sure that gets completed.
It's not objection. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond continues.
So what was the date again? Your Honor?
August 7th.
Thank you so much.
The last.
Court calls case people versus Sean Hardman.
Good morning, Your Honor. Christina Costantino, standing in for Attorney of Record Sydney Rushing on behalf of Sean Hardman. Unfortunately, Judge, it doesn't appear that Mr. Hardman is here. I did look for him in the galley, and I don't believe he is here. I'm sure there's a very valid explanation for his non-appearance, but we would ask the court to consider an adjournment.
Just point out there's a bond violation.
I do see it. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you very much, Judge.
Thank you. Oh, rushing. She should be here to take her own bench warrants. Court calls the case, People versus Nicole McCauley.
Judge, Judge Fleischer, First Assistant Public Defender, on behalf of Ms. McCauley, who is approaching the podium. Oh. Good to see you, Judge. What's your name for the record?
Nicole McCauley.
Thank you, Judge. I have taken the.
It's nice to see you.
Yeah, you as well. You as well.
Sorry? Kind of missed you.
Well,
Where you been?
I miss being here, Judge.
There you go. Otherwise, you would be here.
I don't make my own assignments, Judge. I go where they tell me.
Oh, you've got some pull. Anyway.
It's good to see you. I've spoken to Ms. McCauley, Your Honor. I believe she's requesting an adjournment so we can review the discovery that was tendered by the people. She does want me to make a bond request, Your Honor.
Go ahead. I will. Well, first of all, I'll adjourn it to July 31st.
Okay. Sorry, Judge. Ms. McCauley has a case out of Wayne County that she has a release to a treatment facility on to Naomi's Nest.
Yes.
She is asking if Your Honor might consider a release to treatment in this case as well.
That would be, it was a release to inpatient at that facility?
Yes, sir.
Okay, once again, I'm not gonna have a problem with that. So if you submit a stipulated order to me allowing that release, but unlike what Mr. Elman did, you can put on there that if she fails or leaves, we'll need to return her to Washington County Jail.
Fair enough. Will do. Thank you, Judge. Okay. He said.
All right. So at this time, our bond will continue.
Thank you.
Court does call the case, People versus Todd Averman.
And Alex Warren Green on behalf of Mr. Ammerman. Mr. Ammerman, can you state your name for the court, please?
You'll need to unmute. There we go. State your name.
Todd Ammerman.
All right. I have before me a plea form that indicates that he's going to be pleading guilty to the charge of use of methamphetamine. Upon his successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
That's our full understanding, Your Honor.
Mr. Ammerman, can you raise your right hand, please? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name again for the record.
Todd Ammerman.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Fleischer in the 14A4 District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yep.
And because you believe that you are indeed guilty?
Yes.
Where's that comment from? On the date of October 11th, 2000. Okay. It's his device. Mr. Amerman, however you had your device set, you changed the settings.
Hello?
Hello, can you hear me?
Yes, I can.
Okay. Either that or somebody came into the room. On the date of October 11th, 2023, location of Church Street, City of Milan, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did.
Had you used it?
Earlier that night, yes.
And did you know what you were using was methamphetamine?
Yes.
Counsel, have I complied with the court rule? Well, I won't ask that at this point. Sir, you do understand that if you commit misconduct between this time, if I accept your plea between this time and the time of your sentencing, that any evaluation or sentencing recommendation, the court would no longer be bound by, and you also would not be allowed to set aside your plea in this case. Do you understand that, sir?
Yes, sir.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements that have led to this plea?
None from the defense, Your Honor.
Have I complied with the court rule, and would it be proper to accept the defendant's plea?
And the defense is satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing will be
September 30th, 2025 at 9 a.m. with Judge Fleischer.
September 30th, 2025, 9 a.m. before Judge Fleischer. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Ahmad Metwali.
Ready in that matter, Your Honor. Honor Lauren Brown, Deputy Chief Public Defender with and on behalf of Mr. Metwali. Mr. Metwali, state your name for the record.
Ahmad Metwali.
Thank you, sir.
Your Honor, today is the date and time set for the probable cause conference. That's a little bit of history. Mr. Metwali was originally scheduled for a competency review. He has since been found competent. There's a criminal responsibility evaluation that is still outstanding. However, we have chosen to waive our right to preliminary examination and agreed to have this case bound over to circuit court, where we will await the finding on the criminal responsibility.
Sir, is that correct? You're waiving your right to have a preliminary examination?
I really do not understand this part of the process. I was.
Okay, so let me just ask you this. Right now, this is set for a probable cause conference.
Yeah.
A number of things can happen at this probable cause conference. One is that I could set this for a preliminary examination, basically a mini trial in essence, except typically the defense does not call witnesses. At that proceeding, the people would be required to show 2 things by a standard of probable cause. First, that there was a crime or crimes committed and that you committed those crimes.
Okay.
All right. You understand that?
Yes. So
what your attorney is indicating to me is that you do not wish to have that hearing and that you wish to proceed to the higher court, that being the circuit court, for further resolution of this case.
And at that point, we will be.
I was going to plead not guilty by reason of insanity.
Hold on. We talked about this. So the way to do that is like I told you. It's the way we're going to check the court.
Okay.
And for this criminal responsibility, but you not understand that?
Yeah. So.
Yeah. So you need to stop talking and listen. We've already talked about how to proceed to do that.
Yeah.
You agree that you did it this way. Do you still agree to do it that way?
I just do not understand if there's any other option to wait for the criminal responsibility. So I want to wait for the criminal responsibility report.
You want to wait for that?
Yeah.
Okay. So that's what your attorney's trying to do. He's trying to get you to circuit court because this court would not deal with criminal responsibility.
Okay.
All right.
Okay.
So you would like to waive your right to have a preliminary examination?
Yeah,
Okay, and you understand that that's that proceeding or hearing that I talked about, where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yeah,
Okay, you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
yes.
All right. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all four counts.
Thank you, Your Honor. We acknowledge receipt of the information. We waive its reading on the record. My client has executed the examination waiver and he will be entering a plea of not guilty.
Defendant having waived.
Also, I want to clarify that it's confusing when my actual lawyer is not here. Because Jay Bellinger is my lawyer.
Okay, so Jay Bellinger is a part of an office
Okay,
of which the gentleman standing next to you is second in charge.
okay, because it's confusing because I thought my lawyer would be here. And my lawyer had.
Well, they are. Mr. Bellinger has, I'm sure, spoken with Mr. Brown and given him specific instructions as to how Mr. Brown is to handle this case, which he's probably done admirable.
Thank you.
Okay,
Okay?
okay.
All right.
Thank you.
So defendant having waived reading and pleading not guilty to all four counts, court will enter that plea. Pretrial in this matter will be set
August 7th at 1:30 with Judge Slay.
August 7th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Is that the circuit court?
Yes, that's in circuit court.
Okay.
Bond will continue. Thank you.
Thanks.
Thank you, Your Honor.
Court calls the case People versus Christopher Adkins.
Andrew Banks for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins, Your Honor, but not with him. I did receive information yesterday and confirmed in Vine Link that he is in the Livingston County Jail.
In Livingston County Jail?
Yes. I'd ask for an adjournment so that a writ can be done.
So we're gonna have to go to the 7th. See, do you know if he's still gonna be there?
I have not had any contact with him. I think he just went in the last couple days.
August 7th, 2025, 9 a.m. On continue. Case People versus Brandon Kelly.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Kelly.
Your name, sir?
Brandon Kelly.
Thank you.
Your Honor, today is the date time set for the probable cause conference. There is a mitigation report, which we are still hoping to receive very shortly. We'd ask for 2 weeks to make sure that report has been completed.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continue. Thank you. Court calls case People versus Anita Burns.
Someone for the judge. Portia First Assistant Public Defender on behalf of, but I do not believe with, Miss Anita Burns. Your Honor, we've called, we've texted, and we've emailed our client. We have not heard from her. I do not know why she's not present. For the record, I will request an adjournment, but I do not know where she is.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you very much, Judge.
Court does call the case of the People versus Carl Murray. 2 cases.
And Assistant Public Defender Chinaza Kyriaki, Your Honor, on behalf of Mr. Carl Murray, who is approaching. Mr. Murray, state your name for the record, please.
Carl Murray.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination. That's both matters, Judge.
Both matters.
Yes, please.
Discovery complete.
To our knowledge.
Would the people have their witnesses available The 5th. Preliminary examination in person, August 5th, 2025. 9 a.m. That is before Judge
Judge Perry.
Perry in both matters.
Thank you, Judge.
Bond continued.
Thank you.
Court calls case People versus Adonis Sweat.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Wendy Burnwell, P42 505, on behalf of Mr. Sweat.
Adonis Sweat. Adonis Sweat.
Thank you. What are we doing?
Well, I'm brand new to this case, just accepted it. And
You want the 31st? You want, pardon?
Mr. Sweat is co-defendant with Monte Owens, who is set for the 7th, I believe.
The 7th. All right. Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
thank you.
Bond will continue. Thank you. Thank you, Mr. Sweat. Court calls case People versus Timmy Abazulu.
And then on behalf of the people, Your Honor.
Stephanie Cannon on behalf of Bitimi Buzulu. Could you state your name for the record?
Bitimi Alexander Buzulu.
Buzulu.
Okay, what are we doing?
Your Honor, I have I do. I have a green sheet on him. We're requesting an adjournment for investigation.
He's in custody. The 31st will work.
Yes, Your Honor, the 31st will work.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continue.
And I will just a second.
Court does call the case of the People versus Roderick Bates. Did I speak French again? I did. I hate that when all of a sudden I just transition into a language that I can really cannot understand.
Excuse me, Judge. Assistant
Oh,
Public.
no, we'll wait for you to finish talking as we had to for you to get up.
Assistant Public Defender Chinazi Carey. I can really, Your Honor, on behalf of Mr. Roger Bates, I do have a green sheet, Judge.
But do you have a client?
He should be on Zoom. Is he not on? Oh, man.
Bates? We're moving along swimming.
We were doing so well. Judge.
I was.
Even with my last case, we were just.
What?
Even with my last case, we just right on there.
You can't have more than one good one in a day, can you? There's an individual who's on iPhone 2. Could you unmute and state your name, please?
Chavez.
My name is Montez King.
Okay.
You got him? Nope. Not him. Okay. Thank you, sir. There's an individual iPhone 1. Can you unmute and state your name?
Anitha Barnes.
Got her. What? That's a bench warrant? Oh, I'll let you tell her. Okay. And an iPhone 3. Is an individual iPhone. I don't see iPhone 3. Oh, there he is. iPhone 3. What's your name, sir?
Jelani Wright.
You got him.
None of those were engaged.
Right. And there's another individual, Samsung. Could you unmute and state your name, please? Individual signed on as Samsung. Pen. Bates. They're not here. Hmm? Oh, she can have the green form back. That's not gonna help.
Thank you.
Anything else you gotta say?
Judge,
For the
we,
record, you're requesting an adjournment.
for the record, we are absolutely requesting an adjournment. We've been in contact with Mr. Bates, hence the approval from the court for him to log in on Zoom. I do not know why he's not there.
Oh, well.
Yeah.
Bench warrant, 10,000.
Thank you, Judge.
Cash surety. Warrant will issue immediately. Court does call the cases of the people versus Joshua Pelfrey.
Alexander, on behalf of the people, Your Honor.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, being and on behalf of Alfred.
Your name, sir?
Joshua Pelfrey.
All right. What have you done this, Mr. Brown? These. It's 4 cases.
Your Honor, today's the
5.
date.
Sorry.
Your Honor, today's the date and time set for a probable cause conference. We still don't have all the discovery. We're pending discovery on adjournment. Well, we should.
If Your Honor,
I don't want an adjournment.
all 5 of your cases
Well,
will
we
be
can't do
once
anything about
requested.
this.
I'm not saying adjournment. I got due process. I need my.
By the end of the secret meeting of next.
I'm gonna tell you that we
That
need
can be
adjournment.
that.
All
I
right.
don't want an adjournment. I want to schedule a preliminary examination.
Your Honor, we would like to be able to have the discovery. We, despite my client's misgivings, would like to have an adjournment to get that discovery. He wishes not to have an adjournment and schedule it for preliminary examination. I'm advising him that that is not the proper or appropriate way to handle.
And Your Honor, on one of the cases, they haven't even received any approval yet. It's just releases.
It's because some of the cases are, I need a preliminary examination.
What? I can't hear you.
I don't want an adjournment. I want a preliminary examination. I don't want to keep adjourning my probable cause conference and pushing out my prelim. We got a right to due process, 14 days.
Okay, you want due process? We'll give you due process. Give me a date before me. We'll just do it. And then that way, when your counsel doesn't have discovery, you have no complaint against counsel. When it just goes south for you. Now, I need a date earlier than that.
That's a bad idea.
So they don't have that.
I'll set preliminary examination in person before me, August 4th. That's a Monday, 2025, 9 a.m. I will indicate that while I'm setting it over the objection of defense counsel at defendant's request, that if the discovery is not there, they haven't analyzed it, we're still going ahead. Put that in the file. He wants an exam, I'll give him an exam. Thank you. Bond continue.
For the record, I want to make it clear that this is against counsel's advice.
Yes, and I've stated that, and I've noted that Mr. Brown, this is against his attorney's advice. He wants to do that with his own law degree. Thank you. Bye.
Thank you.
You do the same, Mr. Pelfrey. Court calls the case, People versus Bradley Chavez.
Assistant Public.
Is this yours?
It is mine.
Is this gonna go well? No, is this gonna go well? Ms. Akinrulli, is this gonna go well?
It's
'Cause
gonna go
you've
great,
had
Judge.
3
It's gonna go.
and you're 50% right now.
Go.
Oh,
His shirt matches.
Mr.
straight
Chavez. Can you state your name for the record, please?
Bradley Chavez. Morning, Your Honor.
Thank you, sir.
He's matching the green sheet, Judge.
Yes, he is.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Chavez. Your Honor, we are in the midst of negotiations. I think the people and I may have come to a resolution. I just need to let Mr. Chavez know. And hopefully we can get this resolved at our next hearing. So we're asking for an adjournment.
August 7th,
Thank you.
2025, 9 a.m. Thank you, sir.
Thank you,
Bye.
Your Honor.
Court calls the case, People versus Abdul Scott. Whose case is this? And I know because she's not here, because that just happens with her. Can somebody find Miss Cannon?
Assistant Public Defender Tanazi Carey, I can really, on behalf of Mr. Abdul Scott.
You're not Miss Cannon.
I'm not, we look alike a little bit.
Oh, okay, got you. You are so wrong. Your name, sir?
Abdul Scott.
Thank you. All right, what are we doing?
We're asking for an adjournment, Your Honor. I did. I'll get the form, the court agrees to you, right?
All right. I'll adjourn it to July 31st, my next available date, 2025, 9 a.m. bond continue. All right. Thank you, sir.
Thank you, Your Honor.
We need to go to the chief whenever she decides. Where'd Cannon go?
Double duty, Judge.
So she chose the other duty instead of this one?
No,
Is that what you're telling me?
She has.
She chose to be someplace else than before me.
They dragged her kicking and screaming. I said, no.
Was it kicking and screaming? Okay. Oh, apparently she survived. Hello, Miss Cannon.
How are you?
So just out of curiosity to see if they were telling me the truth, where were you?
Next door,
Did they drag you over there kicking and screaming?
they asked if anybody was available.
And so you volunteered to leave here and go there because you'd rather be there? Is that what happened?
Never.
That's not what happened?
You didn't see them drag me out?
You and Lauren Brown ought to stop. Court calls the case, People versus Deshaun Clifton. Just in time.
Stephanie Cannon on behalf of Mr. Clifton. Mr. Clifton, could you please state your name for the record?
Clifton.
Your Honor, I did receive some information this morning regarding our plea negotiations from Mr. Banis. I have not had the opportunity to review that. I'm asking for a 2-week adjournment.
I'll adjourn this case August 7th, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Thank you, Your Honor. Thank you, sir. Thank you. Court calls case. Oh, this is the one she missed when she was someplace else. Is that this one, this green form? That didn't get to me even though I granted the adjournment?
That is correct, Your Honor.
Because Miss Cannon was someplace else that she preferred to be other than here before me?
I'm gonna talk to them about assault by strangulation. Based on what happened.
I'm telling you, what they told me. Court calls case, People versus Collins Fry.
Assistant Public Defender Alexis Artswithan on behalf of Mr. Spry, who's approaching. If you can state your name for the record, please.
Colin Joshua Spry.
Your Honor, we'd respectfully requesting an adjournment. We're currently in plea negotiations with the people.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Okay. Court calls case, People versus Michael Frazier.
Andrew Bannon for the people. Four shall face the first assistant public defender on behalf of Mr. Michael Frazier, who I am told is on Zoom.
Yes, I'm here, Michael Frazier.
Oh, there he is. State your name, Mr. Frazier.
Michael Frazier.
Thank you.
I'm also told that Mr. Frazier intends to do a waiver to circuit court. I had initially planned to adjourn it, but I don't know that we're gonna need that if the court will.
Okay, so he's waiving.
Yes, that's my understanding,
Yes.
Judge.
All right, is that correct, Mr. Frazier?
Yes, sir, Mr. Simpson, sir.
Okay, and you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, yes.
Yes, sir. Okay. People also waive their right.
People waive their right.
Preliminary examination having been waived, defendant's bound over to circuit court on both counts. Mr. Fleischer.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
At 1:30 with Judge Fleischer.
September 16, 2025, 1:30 before Judge Conkey.
Thank you, Judge.
Bond continued. Thank you.
I'm done, Mr. Simpson.
That's, yeah, you're all set.
Okay, thank you. Appreciate it. Have a good day.
Thank you.
All
You
right.
too. Court calls the case, People versus John Outcall.
Andrew Daniels.
Stephanie Cannon, on behalf of Mr. Holt.
John Paul Outcall.
All right, thank you.
You're welcome.
And Your Honor, this is another case. This is another case where we did receive an offer, so we're going to ask for an adjournment so I can convey that offer to my client and see how he would like to move forward.
July 31st, 2025, 9 a.m. Bound continued.
Thank you, Your Honor. My client is asking for release on bond at this time. My client is homeless, but he can receive mail at the Delanis Center. Sometimes that mail is probably not the most reliable. So my client is asking that he be released on a PR bond to Delanis. He will be here for court and for any other appearances that the court is requesting.
Well, where was he between October 24th, 2024 and the day he came back into custody?
I was homeless, Your Honor.
Did he turn himself in?
No, but I didn't know I had warrants out for my arrests.
Well, originally released on a personal recognizance in October. Then that next date, he didn't show up. We issued a warrant and he didn't come in nor have contact with his attorney, apparently, who would have told him that a warrant had been issued. At this time, the motion for bond reduction is denied. Bond will continue.
And I'm sorry, what was the next date, Your Honor?
It's set for July 31st, my next available day.
Thank you so much.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Darius Grady.
Good morning, I'm Amy Visor, on behalf of People.
Torshell Feaster, First Assistant Public Defender, on behalf of Mr. Grady. Mr. Grady, please state your name for the record.
Darius Greg.
Thank you, Judge. My understanding is that mitigation information has been turned over to the people. I'm asking for an adjournment for 2 weeks for further negotiation and for their consideration.
Without objection, probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you very much, Judge.
Court calls case People versus Samuel Peoples. Watch behind you, please.
Stephanie Cannon on behalf of Mr. Peoples. Mr. Peoples, could you tell your name to the court.
Samuel Peoples.
Thank you.
Your Honor, the court is very aware of Mr. Peoples and some of the issues that we're having. We are asking for an adjournment. Can we put it on the same date as the last one, which I think you had did 3 weeks from last Thursday? Am I correct?
That would be August 7th.
On August 7th. So I'm going to ask that you adjourn this to August 7th so these cases can run together for hopefully a global resolution.
August 7th, 2025, 9 a.m. bond continue.
And Your Honor, as far as bond, the court is aware that we did file a stipulated order asking for Mr. Peoples to be released. It's my understanding the court did sign it. We were just asking for the same conditions to be applied in this case.
What? Did I sign an order?
Yes, sir. You
I
signed,
did.
you did.
So what more do you want from me?
Nothing. I'm just happy to see you, as is Mr. Peoples, correct?
Yes, sir.
Yes. Yes.
If we wanted that to apply to this case as well, no objection.
Yeah, that was signed on the other case. You want, and you
Nope,
want,
nope. I want you to be happy and do great things.
it's not happening when you keep talking. Right. So what do you want me to do? You want it on the other, you want it on both cases?
Yes, sir.
Is that all you want?
That's all I
Did you
want.
submit another stipulated order to me? No?
No, I will get it.
Otherwise,
to you-
I'd be thrilled to sign it.
It'll be to you in like less than 5 minutes.
That's probably not true.
That's probably.
That's probably not true. Mr.
That's
Buscaino.
probably accurate.
So how much time do you need to get it to me, Ms. Cannon?
I'm gonna do it at 10 minutes.
Give her 15.
Thank you, Your Honor. Thank you, Your Honor.
I get it. Yeah.
So my homework weight somehow.
Court calls case People versus Alexander Calarossi.
Ready, Your Honor. Your Honor, Joe Simon on behalf of Mr. Colarossi. Alex, state your name when you get up here. Alex Colarossi.
Got it. So what are we doing, Simon?
I think,
Mr. Simon.
sorry. Yes, Your Honor, we're requesting an adjournment of the probable cause conference. There's I won't quite call it a companion charge, an identical charge in the county of Kent. There's a circuit court pretrial that occurs on August 4th in that matter, asking to adjourn our probable cause conference to a date after that date, where we're going to try to have a coordinated resolution to the extent we can. I also want to make a statement. I understand the complaint is present in court. I've given my commitment to the people. That is not our intention to ever have a preliminary exam in this case. We are seeking resolution.
Do you want the 7th or the 14th?
Probably be smarter to do the 14th, Your Honor.
I think you had your other stuff set for the 14th. I don't know why I keep track of your schedule, probably.
Because you really enjoy seeing me.
No, it's probably so I can see the fewest amount of times that would be my guess. The 14th.
Thank you, Your Honor.
You're welcome, sir. Probable cause conference in this matter will be during August 14th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you.
Go home.
Okay. Court does call the case of People versus Derek Stewart.
Maybe I read that for people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Stewart, who is approaching now. Mr. Stewart, will you state your name for the court?
Mr. Derek Stewart.
Thank you.
So we're still waiting a review.
Correct.
A report on the review.
Yes, we'd ask for an adjournment for that purpose.
Why don't you give me, let me just, so. Does anybody contact anybody regarding when a report might be here?
Your Honor, I'm standing in for Miss White. I don't know if she reached out to the forensic center. I can leave a note for her and ask that she do that.
All right, why don't I do this then, just so we, because I can set it out and then move it up, but why don't we set it for September 11th? We get a report before then we can move the date up. September 11th, 2025, 9 a.m. Bond continue.
Thank you.
Yeah. Court calls the case People versus Norwin Rouse.
Allen, on behalf of people, Your Honor.
Your Honor, Joe Simon, on behalf of Mr. Rouse, state your name, Lord.
Norwin Rouse.
And before me, a plea format indicates defendant will be pleading no contest to the charge of domestic violence. That being a misdemeanor punishable by up to 93 days. Upon his successful plea to that charge, count one would be dismissed. He agrees to complete a full 18-month probation term. There is also a sentence agreement or a recommendation to the judge of no upfront jail. That's the court's full understanding.
And that's correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Norwin Robert Rouse.
Sir, and advice of rights form.
Fill one out today, Your Honor. Should be there for you.
Oh, okay. I got it. Holding on to the police report. All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence. Is that correct?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Fleischer in the 14A4 District Court. You understand that?
Yes, Your Honor.
Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
Guilty.
No contest.
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5, you see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
you? Doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 3831-25. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, you understand that if I accept your plea and you commit misconduct as defined by the Michigan court rules prior to your sentencing date, that the court would no longer be bound by any evaluation or recommendation?
Yes, Your Honor.
You also understand that you would also be prohibited from withdrawing your plea?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
July 31st at 10:30 with Judge Fleischer.
July 31st, 2025, 10:30 before Judge Fleischer. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor. It'll be, yeah, here.
Wherever 4 is.
It's here.
It's not here.
Well,
Mythical.
hey.
They're here
B.
temporarily. Soon they will be leaving.
The court is generous. The court is
I
kind.
know, I allowed stuff. Court calls the case of the People versus Bryce Valero.
Andrew Van, people on both cases.
There are, there are, Your Honor. Alex Warren Green on behalf of Mr. Valerio. Mr. Valerio, can you state your name for the court?
Bryce Valerio, Your Honor. Thank you.
Your Honor, at this time, we are asking the court to set both matters for preliminary examination.
Discovery is all complete.
So, Your Honor.
People have their witnesses available August 5th.
People will do their best. Your Honor. Thank you.
Preliminary examination in these matters will be set August 5th, 2025. 9 a.m. That will be before Judge Fleischer. And in each of these matters will continue.
I'll talk to you before that. Thank you, Your Honor.
Thank you, sir. That's called the case of the people versus Derek Stevenson.
Ready in that matter. On Brown, Deputy Chief Public Defender appearing with and on behalf of Mr. Stevenson, who is appearing by Zoom. Mr. Stevenson, could you please state your name for the record?
Stevenson.
Thank you, sir.
Your Honor, there is still video discovery, which is outstanding. We think that, a week should be sufficient?
Yes, Your Honor, the ones that we have ordered that was just signed, this morning, I believe.
Probable cause conference then will be adjourned July 31st, 2025, 9 a.m. On continue.
Thank you very much.
Thank you. Court does call the case People versus Fred Willis.
And Alex Warren Green on behalf of Mr. Willis. Mr. Willis, can you state your name for the court?
Fred Willis. Thank you.
Your Honor, we are still working on completing discovery in the discharge at a building case. I have completed a green form for the court. We're asking for
both then?
Both, please, Your Honor.
Okay. How much more time did you need to try to get discovery done?
Your Honor, I believe we could complete it by the 31st. I would defer to the people, though.
What is it you need?
Media.
Probable cause conference in this case will be adjourned July 31st, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Thank you. Case of the People versus Myron Barnes.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Barnes. He's appearing on Zoom from Don Farms treatment.
Mr. Barnes, can you state your name, please, sir? Myron Barnes. I'm asking for an adjournment on this.
Yes, Your Honor.
Probable cause conference in this case will be adjourned August 7th, 2025, 9 a.m. Bond continue.
Appreciate it, Your Honor. Thank you.
Thank you.
In touch, Mr. Barnes.
All right. Court does call the case People versus James Herring.
Andrew Van for the people.
Brown, Deputy Chief Public Defender appearing on behalf of Mr. Herring. Now today's date and time set for the probable cause conference. My client is in prescription glasses, and of course, that's why.
Why are you telling me that? I didn't ask. I didn't ask, I was just looking.
They're nice.
It happens when you look and people feel guilty, they just start confessing things. Go ahead.
They're nice. They're nice.
No, that's okay. No.
So we do have a plea offer. My client is willing to accept it, but we need a week to be able to get the form to the court. So
Probable cause conference, July 31st, 2025, 9 a.m. Bond continues.
thank you.
Thank you. Good luck. Did he give me a green sheet? No.
I didn't do a green sheet.
Just got blinded by the light. The client could see, I need a green sheet. Court does call the case. People State of Michigan versus Stephen Johnson.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson, who should be appearing via Zoom. Oh, good. Your Honor, we're asking for an adjournment for some continued plea negotiations and to track progress of Mr. Johnson. Indictment. Mr. Johnson, can you say, sorry, Mr. Johnson, can you state your name for the record?
Steve. You're muted now. Okay.
My name is
Go ahead.
Stephen Michael Johnston.
Thank you. All right. Will the 7th be enough time for you or?
Yes, Judge. I
We're
think so.
tracking them.
Yes.
All right. Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you, Mr. Johnson. Court calls case of the people versus Marcus Jones. Oh, boy. Here we go. Gonna take a minute.
Good morning, Your Honor. Student Attorney Andra Sabri requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinruli.
Really? Have you always been with her?
Yes.
Really?
Yeah.
No. I didn't notice. She must be a good leader. Permission to not really. Don't nod your head. When you gotta, it's not, if I say that, you don't like sign on yourself. You let other people. Permission to practice is granted.
Thank you, Your Honor. Mr. Jones, state your name for the record.
Marcus Jones.
Your Honor, at this time, we are requesting an adjournment to continue negotiations with the people.
Probable cause conference, I'll adjourn August 7th, 2025, 9 a.m. Bond continued.
Your Honor.
All right, thank you. This is, the other one. Court does call the case People versus Montez King.
Read in this matter, on the Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Montez King.
Mr. King, state your name, please.
Montez King.
Thank you.
Your Honor, today's date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination at the earliest possible date. We believe that all discovery has been to us.
People have their witnesses available the 4th. Preliminary examination will be set August 4th, 2025, 9 a.m. in person before Judge Perry.
Be in person for that, Mr. King, okay?
Okay.
All right. Bond continued. Thank you.
Thank you.
Court calls case People versus Alexander Cronin.
Stephanie Cannon on behalf of Mr.
Good morning, Your Honor. This is Alexander Cronin. How are you, sir?
That's the wrong one, Your Honor. That's on me. Stephanie
Oh, I
Cannon.
knew it when you made that poor guy get up.
He's a
No,
great
you
guy.
made him get up.
I made him get up.
Afraid to do anything else.
I'm
It is all
intimidating.
your fault because I saw Mr. Cronin on Zoom.
I'm so.
Why did you apologize to that man? All right, thank you. What are you doing now, Miss Cannon?
We are just asking for an adjournment in this matter for continued negotiation.
That objection, I'll adjourn this to the 7th.
Seven.
Okay.
Thank you so much, Your Honor.
Thank you. August 7th,
What time is it?
2025, 9 a.m.
August 7th at 9 a.m.
Thank you. Enjoy your day.
Continue. Thank you. Sir, what's your name? Pardon? Since Miss Cannon yelled at him and made him do all of that, I'm gonna call his case. Yes, you did. Yes. Court calls the case, People versus John Michael Nowak.
Alex, then on behalf of the people, Your Honor.
Stephanie Cannon on behalf of Mr. Nowak. He just looks like an Alexander.
What?
Looks
like what?
An Alexander.
Oh, is that how you figure out who your client is? Is that what you do?
In that moment,
I call the case, she goes, he looks like an Alexander, come on up. Is that what you did?
Yeah, it's like, what? We literally talked this morning. Like, what?
Oh, we talked.
Yes.
You made an impression. Wow. Cannon.
well, good news, Your Honor, it's for a plea.
No, I do see that. But this plea form's for Alexander.
No,
I'm kidding.
Oh,
All right.
I was like,
You
oh my
just
God.
you absolutely froze.
I did.
You had no. Sir, did you state your name?
No, I didn't. I'm sorry.
Could you state your name so she knows it now?
John Nowak.
John Nowak.
I have before me a form that indicates that the defendant will be pleading guilty to count 2, which is malicious destruction of property, 200 to 1,000 to 1-year offense. Upon a successful plea to that charge, and count 1, right, would be dismissed. Defendant also in this is agreeing to pay restitution in the amount of $1,635. And that he would be sentenced under a prosecutor's, there's a sentence agreement of sentencing under a prosecutor's preferred.
That's correct, Your Honor.
That is my complete and full understanding of the agreement.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
John Nowak.
Did you say your last name?
Nowak. Yeah.
Okay, thank you. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that could become the maximum fine. You understand that, sir?
Yes.
Okay. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. Do you understand that, sir?
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights, which you should take a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
Not yet.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Very much.
On the date of June 4th, 2025, at the location of 1235 Astor Avenue in the city of Ann Arbor, Washtenaw County, state of Michigan, what did you do involving a Honda Civic belonging to Olivia, is it Holsing, that makes you think that you're guilty?
I drove there. I mean, I could give the whole sob story.
Just tell them what you did.
But what I did was that I drove there. I spray painted cheater on the left side of the car, liar on the right, and FU across the hood.
Because, yeah, that would be a long story, probably
Yeah.
to tell.
Yeah.
Okay.
All that matters.
You were angry about something. You went up and damaged your car.
All that matters is that I'm here to take accountability for what I did. Chelsea advised me against bringing it. I do have these here to show that they're statements from friends that know me.
That'd be, if we do, it'll be for sentencing judge, not for him. He just
Sorry.
needs the facts and he's
Okay.
gonna.
But
act
I'm sorry, I'm getting ahead of myself. But yes. That I did that.
Do you agree the amount of the damage was at least $1,635?
At least yes.
Pardon?
At least yes.
Yes. All right.
Sorry.
Okay, so I do have to advise you. I do have to advise you, sir, that if you commit misconduct after I accept your plea and before sentencing, that any type of evaluation or sentencing agreement, the court would no longer be bound by. You understand that?
Yes.
And you would also not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
Have I complied with the court rule, and would it be proper to accept this?
Yes, Your Honor.
The court has.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 15th at 8:30 with Judge Perry.
August 15th, 2025, 8:30 before Judge Perry. Bond will continue.
Thank you so much, Your Honor.
All right, thank you.
After that.
Court calls case, People versus Michael Laster.
Andrew Banners for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Laster, who's approaching now. Mr. Laster, will you state your name for the court?
Michael Laster. Thank you.
Your Honor, we're asking for an adjournment for continued plea negotiations.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case, People versus Patrick McGee.
Andrew Banners for the people.
I am ready in this matter, Your Honor. Juan Brown, Deputy Chief Public Defender, appearing on behalf of Patrick McGee.
They're not here.
No, Your Honor. I have attempted to reach Mr. McGee. We had wonderful things in place for him. He chose other options. However, having said that, I will be happy to ask for an adjournment of 3 weeks so that we can get Mr. McGee in here and move forward with this.
And I will be equally as pleased to deny your request and issue a bench warrant on 10,000 cash surety.
I had to give it a shot.
I know. That warrant will issue immediately. Watch this. Cannon, do you know the name of the person you're even talking to?
And Alexander?
Okay. Court calls the case, People versus Melvin Morrow.
Assistant Public Defender Alexis Zerbst, on behalf of Mr. Morrow.
who I don't believe is present, Your Honor.
Pardon?
Who I don't believe is present, Your Honor. We made all our efforts to get in contact with him, had no luck. I have no other explanation for his failure to appear. We'd be requesting an adjournment for the record.
Bench warrant will issue for defendant's failure to appear. Bond 10,000. Cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Alexis Naveen.
Andrew Banish.
Oh.
And Alex Warren Green on behalf of Ms. Naveen. Ms. Naveen, can you state your name for the court, please?
Alexis Naveen.
How are you?
I'm doing much, much, much better. Thank you, Your Honor. Thank you for your patience.
My patient?
Yes.
You need to thank me for anything. I think I told you before, I had to thank you because you served and allowed me to do this every day. So if I have to wait for you, I wait for you.
Thank you, Your Honor.
But we've had a long journey, right?
Yes, sir.
Okay. And so it's just fantastic to see you here.
Thank you. Thank you.
What are we doing? You did an adjournment on us.
We are requesting an adjournment, Your Honor. We are trying to alternatively resolve this case. Our hope is that Ms. Naveen can enter the Veterans Court. She's set to be sentenced on August 4th, I believe.
On what day?
August 4th.
Okay.
And we're hoping that if she can get into the Veterans Treatment Court, begin making satisfactory progress in that program, that we can resolve this case and have a little more mitigation available from her progress in the Veterans Court.
So it's another case that she would be sentenced into the Veterans Court.
That's correct. She has a misdemeanor case that has been accepted, and she'll be sentenced on August 4th, is my understanding.
Okay. And that's before Judge Valvo. It's in front of me?
Yeah.
Oh, that's right, because we have.
I believe
I'm sorry.
we'll have to do the memorandum of understanding and transfer it over, but I think it'll eventually end up in the 15th district.
Great. Okay. So, and that's on the 4th before me. So why don't you think the 7th? On the 7th, I know, certainly.
Your Honor, if we could go to the week after that, or
14th. If you want to, I'll do whatever.
I think by the 14th, we'll have a good idea of what we're going to do in this case, Your Honor.
All right. Probable cause conference will be adjourned then to August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Okay.
Let's take care of yourself.
Thank you, Your Honor. As well.
Court does call the case, People versus Ryan Patterson.
Andrew Childers appearing on behalf of the people.
And Alex Warren Green on behalf of Mr. Patterson. State your name.
Ryan Patterson.
Thank you, sir.
Your Honor, in speaking to my client, Mr. Patterson has indicated to me he wishes to retain private counsel. He does qualify for the public defender, but I'm asking for an adjournment for that purpose.
How long is it going to take him to do that?
Your Honor, I would ask for 2 weeks.
You're going to be able to get it done by then?
Would you better do like 30 days?
No. I will grant an adjournment for you to get counsel, but I'm not going 30 days.
Your Honor, if the court could accommodate 21 days.
The only time I'll grant an adjournment for this purpose, probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Brent Person.
Andrew Banish.
Ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Brent Person.
Like two in a row.
Yeah, that never,
I know it never happened.
I think the bus must have broken down.
We go through that whole bus like, but you got underlings that you could have sent up here to let them take the head.
Yeah, I know.
But a true leader doesn't do that.
There you go.
You're not here. Bench warrant will issue for defendant's failure to appear, bond 10,000, cashier.
Thank you.
Warrant will issue immediately. Court does call the case of the people versus John Riggs.
Andrew Banish, for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Riggs, who's approaching now. Your Honor, today is the date and time set for an adjourned probable cause conference for Mr. Riggs as well as bond violation. We're asking for an adjournment for some mitigation that we are working on. And additionally, I guess an adjournment of the bond violation. I know that the court previously allowed it to be adjourned based on the number being so low, and Mr. Riggs was placed on a scram tether. My understanding is that there's been no issues since the scram tether. I know that the prosecutor's office did have some communication with the tether SoberLink agents regarding that, and I forwarded, that was with Mr. Ward, and I forwarded those to Mr. Banis. So I don't think at this time the state is wishing to proceed on the bond violation. Did you have a chance to review those, Mr.
Yeah,
Banis?
can we approach on that? Please. Thank you.
He has an interview scheduled with our social worker this week. I think actually tomorrow. So a couple weeks so we could get a status check-in at least.
August 14th, 2025, 9 a.m. Bond continued. That way you can get the information, get it to them, and hopefully have an answer.
Sure.
All right.
Thank you, Judge.
Thank you. Bond will continue.
Right.
Court does call the case People versus DeAndre Cersei.
Thank you, for the people.
Morning, Your Honor. Assistant Public Defender Alexis Simpson on behalf of Mr. Searcy. Can you please state your name for the record?
Doing great. Thank you.
Your Honor, we'd be respectfully requesting an adjournment. The people have extended an offer and we need some time to go over that with Mr. Searcy.
Probable cause conference, I'll turn it out August 14th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thanks, sir.
Thank you. Case People versus Tyrell. Is it Bollocks? Sarah?
And Assistant Public Defender Cedric Simpson, really on behalf of my clients. Tyrell, state your name for the record, please.
Arrail Vox Chisera.
All right. What are we doing?
We had some discussions about revising the language that was an issue for the court the last time. As of last evening, I believe that we have a version of it that should work. However, I have not been able to actually generate that revised plea form. And at this point, I think it would probably be best if we could send it to the court ahead of time anyway, so that if there are any other concerns, we'll know about them and be able to address that time next year. So I think that Ms. Perry really sent the green sheet for next month.
During this matter, July 31st, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, sir.
Thank you, sir. Court does call the case People versus Emarion Williams.
Maybe originally for the people.
Good morning, Your Honor. Student Audra Sabri on behalf of Mr. Williams. Mr. Williams, say your name for the record.
Marion Williams, Your Honor. Thank you.
Your Honor, at this time, we are requesting an adjournment to continue negotiations.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bound.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Jelani Wright.
Andrew Banish for the people.
Delani, right?
Assistant Public Defender, Chinaza K. I can really, Your Honor, on
What
behalf.
happened to Ken?
I
I'm just trying to cover her.
And I respect that so much. Right. Stephanie Cannon on behalf of Mr. Wright. Your
He's
Honor,
already stated his name. You weren't here, but he did.
Your Honor, I'm asking for an adjournment of this matter. I attempted to speak with Mr. Wright yesterday. I'm not sure if the phone number I had was incorrect, but I was not able to get through. So if he could call our office so we could discuss this matter, I would greatly appreciate it.
Got that, Mr. Wright?
Yes.
Call the PD's office, give them a valid phone number and an email for yourself, okay?
Okay.
All right.
Thank you, Your Honor.
So probable cause conference, I'll adjourn on August 7th, 2025, 9 a.m. Don't wait till the last minute to call. In fact, call today.
Okay. Thank you.
All right? Thank you. Bond continued. He's still here. Recalls case, people versus where?
Maybe originally for the people.
Good morning, Your Honor. Edward Drugas on the Michael Ware. Stephanie Cannon will be approaching too. I am on 863. My client has executed a waiver form.
Why are we? Why did we call this back?
I'm aware that he was late, to court, and he's also aware that he was late to court, but Mr. Ware is here right now. We're asking that the court recall the bench warrant.
Please.
What are we doing on the cases?
He is waiving an 863 up to circuit court.
Your Honor, we are adjourning ours so I can have a meaningful conversation with my client. We're just asking for 1 week. I suspect we're going to waive as well, but I'm asking for a 1 week adjournment.
Cancel the bench warrants in these. I'm gonna need new. Girls. Mr. Gerkes's case. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
In that matter, 863, people also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on.
Your Honor, we acknowledge receipt of the information stamped
that are set out in paragraph A of 2205. So I will need to refile, and I've coordinated that with defense counsel. We're going to try to get that done on Monday.
And do it here?
With it being refiled, Judge, it'll go to one of the misdemeanor courts. And I've gone over the language. Maybe you see something I don't, Judge, but to me, I don't see the
Do it
elements.
here, that'd be good if it just doesn't work. Sometimes it just.
You can check me, Judge. I don't think it fits.
Section A.
Yeah, I'm going to go with
is
A.
recklessly.
Yes, sir. The indictment tracks the language under paragraph B. It just would be so much cleaner if you allow me to refile it.
I was looking for a case that would fall right on point that would work for us. It just.
I'm concerned that this indictment doesn't have that language about placing somebody in imminent fear of serious bodily injury. I don't see how I can get that element from what's charged here, Judge. We can assume it, but my preference, since I'm resolving it this way, is to refile it.
Yeah, and that's a safer way, but really, someone, when you read this, someone knowingly discharging a firearm at or in the direction of one or more individuals certainly at least recklessly engages in conduct that places another in imminent danger of serious bodily injury. Firing a firearm at somebody is going to place them in serious bodily injury or death. I mean, but you would think that there would be an easier case decision on that, and that would have been dealt with. And I'm looking at your decisions and I don't see one that's right on point that would help and resolve it. So
if you'll reset this for 1 week, Judge, I should have Mr. Wilson should resolve everything on Monday, and I'll follow up with a dismissal on this case.
Thank you.
okay.
It's coming indeed.
All right, what we just set it for review in 1 week. Is that what we do?
That's fine.
Okay.
I'll have it resolved by then, Judge. Thank you.
Thank you.
Dior Frazier is next.
Thank you.
Thank you.
It's
not right there.
That was a case. That's very fine. Or I've written a letter to packing off about a reduction on that matter. Haven't got a response from him, but yesterday I think we discussed this, and she is in Wisconsin right now.
Who?
Miss Dior. And this is an unusual thing with the other case going on yesterday. I thought the court had agreed to reset that because I knew that with yesterday going on, I wasn't going to be able to get the issue with Mr. Knopf resolved, not by this morning. So I'd ask.
So this was set back on July 1st. We reset this for 3 weeks from July 1st, and says defendant on bond has paperwork from military commitment.
I had the paperwork, but he had sent it to the wrong person in the DA's office, apparently. Had to send it to Mr. Knopf.
So what do we do today to resolve the matter?
I'd ask that we have a couple of weeks just resetting the case. I think there's still a chance we could resolve it, but I was not able to do so by today.
Where's the defendant today?
In Wisconsin, I believe.
On the military commitment?
Well, she's not in the military, but she is still charged with that offense. It has not been dismissed.
She need to be here today.
Well, I thought that the court had excused her because of the circumstance.
I don't think so. I don't remember.
Yesterday, and I told her that her case was still set and the call was filed.
There it is.
But Judge, it's my fault then. I thought that she had been excused.
Well,
I apologize. to the
that's
court.
not your fault. She was told directly she had to be here, so.
And I'd hope that we'd have it with Mr. Knopf, but yeah, because I told her that I did not think she had to be here. Even though I don't have those.
But she said she did. Our coordinator said she did. Spoke to her yesterday. That's her problem. I mean, I opened the door for that, and then everybody who doesn't want to be here can say, I just want to pull what Dior Frazier did, and I didn't think I had to be here. So X is King's X. I'll decide when I show up. We can't do that. We got 5,000 cases. Yeah. Everybody's got to follow the rules.
Well, again, Judge, I think it was my.
Not when she talked to her yesterday, David.
Yes, sir.
She fixed that yesterday when she spoke directly to the coordinator.
Ms. Dior has no prior criminal history.
I'm sorry
She
about that.
graduated from high school about 6 months ago. This is her first criminal case.
Every habitual felon had a first arrest.
Yes, sir.
But I'm not saying she's a habitual felon, but I'm sorry about this, but this, I look at it as what's good for her in that situation is good for everybody. And we can't, then the defendants are deciding when they should show up, not us. And we're the directors of when they have to be here. And then she spoke to the coordinator who any reasonable person to check on it. She called us, right?
She called us. Her and her mother called us
yesterday.
Said she was in Wisconsin. I said the case has not been reset. You still obligated to be here. If you have an issue, you need to speak to your attorney.
And here's the issue is that if she thought so much, if she was so certain she didn't need to be here by some authority, why'd she call us yesterday?
Well, I believe I spoke with her because I thought we discussed it with the court after that time. But obviously, I did not have permission to do that. I should not have done that.
I asked the bailiff to call into the hall for Dior Frazier, please. Dior, D-I-O-R. What's her box?
$7,000.
Dior Frazier.
On those records, I gave you. There's
no response.
No response to the name being called into the hall by the bailiff. No response to that name being called. And again, the defendant has failed to appear, and her attorney, Mr. Grove, is here, and the defendant spoke directly with the court coordinator yesterday, who instructed her that she had to be here like everyone else and on the phone. And thus her bond is revoked, the warrant is issued for her arrest, and certainly it's simple to purge this by appearing. That's what we need to do. Is have her appear to
yes, sir.
Get further information, but I can't treat her differently than anyone else in the same situation. Everyone who wants to abscond can do the same thing, and we couldn't figure out which ones are valid and which ones aren't. But the fact is it's not like somebody told me I didn't need to be here. The court coordinator told her directly that she had to be here. And so, and in the last event, she would have received. Now I'm looking at the resetting that that the defendant signed on 6/27, where she has already appeared. And this, move up, yeah. This is a pretrial diversion matter, right? And is it?
Yes, sir. That's what we're hoping to do. Yes, sir.
See, that's the shame of it all. I mean, now there's a warrant, but I don't know what, I don't know how to treat her any. I would be treating her differently than everybody else in the same situation. And she just needs to figure out how to get here and resolve this as soon as possible.
Judge, well, no, I'm sorry.
Who's the prosecutor on this one, please?
Yeah,
I think it's Mr. Boyd, isn't it?
It is Boyd, it says.
I've heard them conversing on this case, and I know what the state's position is. I don't think we're going to end up where the defense wants to be.
And we may not, Judge. I just want to, I inadvertently, well, not inadvertently, I intentionally told her because I thought the case had been reset, but that's my fault.
So the whole reason why he's trying to talk to Mr. Canales, because we've made a decision to say no at this time.
That's
probably true. But nonetheless, she's talked to our court coordinator, and the court coordinator directly told her she had to be here. And there's paperwork in the file that states resetting. It says 8/28. There's a line through it. 7/22 is placed, and that is pretrial diversion. Move up as soon as possible. She's joining Air Force, has paperwork. I mean, I think we moved this up to 7/22 to accommodate the defendant's needs. That was the plan. What it says, but I don't know. Now, Mr. Ham seems to infer that pretrial diversion is not going to be where this is going to head, which is going to put a kink into her military career.
Well, I don't know where that is, and I have not talked to Mr. Canales about it.
I don't think the United States military deals, retains folks who have felony.
I think you're correct, Judge. And so I think that's why the pretrial diversion.
Well, I know that's what it says, but that's not the way it's worked. It seems to work out. But anyway, she needs to figure out a way somehow to resolve this, but I can't do much of anything other than follow the uniform rule that is in place in all similar circumstances.
Yes,
yeah, we'll bend over back. We don't want people arrested if it's unnecessary, but that's normal protocol in all cases. And especially when it's resolved by direct contact with the coordinator who instructed her she had to be here.
Yes, sir.
All right. If there's some more information, let me know. So I can handle that.
I want to follow my sword here, Judge, because I was the one who told her that, but I did not have permission to do so.
You may have, but
so
I told her differently.
Yes, sir.
It was corrected before the event.
Yes, sir.
It was required to be present, so she knew. And I don't have any further information about why she couldn't make arrangements to get here. I don't have any, without that, I don't have a way of changing the order. Just what I have in front of me is what I'm going to rule on. That would be normal and customary in all similar cases, which is what we're supposed to be all about, and fairness.
That's fine.
All right, we're in recess. Let's get ready for trial. Thank you. And what's our plan on that?
I have a witness to call this morning, Your Honor.
Okay, who's that going to be?
Damian Stewart.
Damian Stewart, okay. The defendant already testified.
That's correct.
What are we doing with Octavia Charles?
She's been recalled and she's testified already last week.
Okay, you're not going to recall her?
No, sir.
All right, so Damian Stewart is the next witness?
Yes.
Then what?
Well, Your Honor, first I have something to put on the record, but outside the presence of the jury.
Well, they're not here and it's outside the presence. Go ahead.
Well, Your Honor, the state has kept the offer open until last Friday at noon. The offer for the murder case was 40 years in Texas Department of Corrections to run concurrent with the pending aggravated assault case. Their murder charge is a first-degree murder, first-degree felony. Punishment range is 5 years to 99 years. And the aggravated assault is a second-degree felony, 2 years to 20 years. And those sentences are to run concurrently. And Mr. Dixon has turned those down. Is that correct, Mr. Dixon?
Which is his right to do.
Yes, sir. And I double checked back on Friday and you turned him down on Friday as well. Is that correct? That's all I have, Your Honor.
Okay. And you're, Mr. Dixon, raise your right hand. Do you solemnly swear or affirm any statements you make during this particular hearing about resolving this case by a disposition of an agreed settlement between you and the party? Everything you're going to say is truthful, so help you God. Okay. You've had a chance to discuss this thoroughly with your attorney. You've thought about it over the weekend. You understand what they were presenting as your option to dispose of this case. And you've thought about it. And your decision, you're making a decision to decline that resolvement in that particular agreement that Mr. Vasquez has just presented as a proposal. You are refusing to accept that, correct?
Yes.
And you're doing that voluntarily, knowingly, intelligently, and based upon discussions with your attorney. Okay, then that's all we need. Ready?
Thank you, Judge.
Let's move forward. Thank you. Please bring the jury in. And the record shall show that all parties are present and the jury is present. It's good to see everyone again. Please, you were instructed, ladies and gentlemen, please recall the evidence that has been presented in this case so far. And we are going to proceed towards the conclusion of the presentation of evidence here. The state had rested. The defense was calling its witnesses when we broke for a week. And this defense may call your next witness now, please.
That's called Damian Stewart.
Damian Stewart. Come forward. Raise your right hand. Do you solemnly swear or affirm any testimony you make here today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Please have a seat. Thank you. Take that microphone and turn it toward your voice, please. Thank you. Yeah, a little closer. Yeah, it has to get closer to you. And then you can turn that, see where it bends, like the neck of it. You can kind of straighten it up toward your voice, but pull it down a little more. Okay, go ahead. Thank you.
Thank you, Your Honor. State your name for the record, please. Damian Stewart. Mr. Stewart, are you chewing gum or you just have a nervous mouth? Chewing gum. Better get rid of it.
Here. Give this to him.
I wanted to tell you before the judge did.
Go ahead.
Thank you for being here, Mr. Stewart. How old of a man are you? How old of a man are you?
How old am I?
Yes, sir.
32 years old.
And where do you live?
Stay in Bowman.
And what do you do for a living?
Working in the refinery.
And where's the refinery?
Huh?
Where's the refinery?
The bean bags.
And how long have you been on that job?
3 years. Went to New Orleans, worked there for 4 months and came back to the same job site.
And you had a business in Port Arthur on Gulfway Drive for a while, didn't you?
Right.
What did you do there?
Audio.
Say it again?
Car audio.
Car audio. But you're back in Sabine Pass now.
Right.
And the early morning of August 6, 2023, you were at work, weren't you? You weren't at Concord in Delaware. Was anybody trying to reach you? Did you get any texts or any phone calls from anybody?
I haven't gotten any phone calls. I had a text from my best friend, Jeremy Dees.
And what were the texts? What did he want you to do?
Wanted me to leave work, come hang out, but I stayed at work.
You can't just leave work and go meet friends.
Really.
Do you know why he wanted you to meet him?
To hang out.
Just to hang out? He didn't say any other reason? Or do you remember?
Well, to hang out, drink, meet some friends, but it's
Now, I know you weren't there, but did Mr. Dixon tell you why he was texting you at any point?
Hey, wait, can we repeat that question? What was he asking him?
Did Mr. Dixon tell you why he had been texting you to come out there? Any specific reason?
Oh, no, it really wasn't a specific reason. It just.
You don't know why? If you don't know, you don't know. I'm not don't reach for an answer. If you know, or if you've learned since then, let us know. If you haven't, you haven't.
No.
You don't know?
You said no.
So how many texts did you receive from Mr. Dixon?
Maybe about 7 or 8. maybe 10. What about it? We was going back and forth, talking about standing word.
So a whole lot of texts, right?
Well, it wasn't about it.
I mean, 7 or 8 texts
10, 5 between me, 5 between him.
back and forth.
Right.
But you never went out there and you never saw what went on out there.
Right.
You just know what Mr. Dixon told you.
Right.
And what did he tell you?
Okay, I'm gonna object to that. Wait a second.
Judge, it's not offered for the truth of the matter asserted.
What's it offered for?
It's offered it's the information that Mr. Stewart got.
It's hearsay. It's not the party opponent. It's hearsay, and you know how that can come in a different way. But the objection is sustained.
Without telling me what Mr. Dixon or anyone else said, did you learn what transpired out there?
Same objection. It's based on hearsay.
Hold on. That last question, do you know the answer to that last question?
What did you just ask me?
Yes, sir.
What transpired?
Yes, sir. Do you just know the answer? Yes or no?
Yes.
How do you know the answer? From what somebody else told you?
Correct.
The objection for hearsay is sustained.
Do you know that night whether or not the man we've been calling Pooh, Ramon Whittington, put a gun to Mr. Dixon's head at any point?
Objection based on hearsay.
Do you know the answer to that, sir?
Yes.
And is it based upon what somebody else had told you?
Yes.
Sustained. It's hearsay.
Do you know whether Gregory Carrington put a gun to Mr. Dixon's head that night?
Same objection based on hearsay.
Do you know the answer to that question, sir? The court has to do this to make a proper ruling. Do you know the answer to that question?
I'm trying to remember.
But is the answer, if you have an answer, is it based upon what somebody else may have told you?
Yes.
The objection for hearsay is sustained.
Judge, allow me to urge my response again. This is not for the truth of the matter asserted. It's just the information that Mr. Stewart has from Mr. Dixon.
Okay, then it has no point in this case. There hasn't been anything before the court that would make it reliable and relevant to any matter that this court and the jury is attempting to resolve in the charges in this case. Record does not show otherwise. Sustained on the objection. Next question, please.
Have one moment, Your Honor. Mr. Stewart, I don't have any other questions for you. Mr. Eckhart may have some, I don't know, but I appreciate you being here. I know you were apprehensive about it. And thank you. Pass the witness.
So you don't remember why Attorney Dixon wanted you to come that night or hang out? Okay. You know who Raymond Whittington is? People call him Pooh.
Yes.
Were you friends with him?
That's my cousin.
Okay. Did you have sex with his wife or baby mama?
Yes.
Okay. So that
But this
is true.
This was over 10 years ago.
Okay. So have you seen Pooh since that all went down 10 years ago?
Still around.
Had he ever been angry with you or tried to get confrontational with you about that?
No.
Did you consider it water under the bridge? I see. So after you believe Pooh knew about that, had he ever gotten angry with you or confrontational with you?
We never was around each other for him to even come at me.
Okay. Had you received anything from anyone to suggest that Pooh was angry with you or wanting to confront you about that?
No.
Okay, so you don't know whether he was mad about that or if he considered it water under the bridge.
Do you understand that question?
I really don't.
Rephrase.
Do you know whether he was angry about that or if he considered it something in the past and it was over and done?
I believe he was probably angry about it.
Okay.
Anything else?
No question.
All right. You are excused, sir. Thank you. Next, please. Defense.
That's rest, Your Honor.
What's that state?
We call Matt Turner.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, but the truth and nothing but the truth, so help you God?
Yes, sir.
Have a seat, please. Thank you.
Thank you, Judge. Morning, Detective.
Good morning.
Tell us who you are and what you do.
My name is Matt Turner, and I'm an investigator for the Jefferson County District Attorney's Office.
So you and me, we work together.
Yes, sir.
Okay, so you pretty much are what keeps all these cases moving.
Small piece of the puzzle.
You and our other investigator, Reggie.
Yes.
Now, after we rested last week, or at least for went into recess on this trial, did I ask you to go and look at one particular issue over at the SNS grocery for us?
Yes, sir, you did.
What did you go over there to look at?
To look at certain camera, surveillance camera angles of view.
Okay. Specifically, were you looking at whether or not there was, well, let me back up. We're familiar with this alleyway, kind of if you're looking out towards Concord to the right of the SNS grocery store where this shooting happened, right?
Yes, sir.
Did I ask you to look on the other side where the pumps are at the cameras that are over there and see what direction they point?
Yes, sir.
Okay. Let me just put in this TV right here, State's Exhibit 1. Okay, Detective Turner, this is State's Exhibit 1, the last file in camera 4 data from August 6, 2023. We're familiar with this angle, right? That's the front right corner of the SNS grocery.
Yes, we're looking at the store that way, the front right corner.
Okay. Now, the clerk explained to us when he testified that there was another set of cameras all the way on the other side over here, close to these pumps, right?
Yes, sir.
Did you go and look and observe not only the orientation of those cameras, but also what what footage they capture from inside the store?
Yes, sir.
And did the clerk let you go in and take photographs of just kind of the view for those cameras?
Yes, sir. Did.
And did you make a, let's see, when did I have my last exhibit?
$62.
you make a diagram of those cameras that I'm showing you here as, it's 163.
Yes, sir, I did. Yes, sir, I did.
Okay, and let me show you states 164 through 170. Lay with those.
Yes, sir, these are the photos I put that.
They fairly accurately depict the camera views and camera positioning and camera angles that you observed when you went to the grocery.
Yes, sir, I did.
Do they also appear to be, for example, looking at what's been admitted as State's Exhibit 12, do they also appear to be the same devices that were present at the store and operational at the store on August 6, 2023?
So I did.
Are we looking at that that corner that you went to look at here in States 12? Is that the same corner?
Yes, sir, looking at the store, the front right.
So I see, correct me if I'm wrong, I see two cameras, one here and one here.
Yes, sir.
Is that what you observed when you went there last week to look at these camera positionings?
Yes, sir.
Okay. We will offer 168. I'm sorry.
164,
Yeah. 164 through 170.
Your Honor, the defense objects to 167, 168, and 169. Just the writing portion on the photograph as hearsay.
You see those? Okay. But
Hold
on. States 164, 165, 166, and 170 are thus admitted without objection, correct? You have no objection to those?
No, Your Honor, our only objection is 167, 168. Excuse me. 167, 168, and 169.
Okay,
I need to ask follow-up questions on those exhibits, Judge.
go ahead. Go ahead.
Yeah.
Okay.
Detective Turner, I forgot to ask you on some of these images that you took, did you actually handwrite identifiers for these camera numbers, meaning those, the numbers that would correlate to the picture that the clerk would be able to see inside the store.
Yes, sir, that's correct.
So we have writing on states 167, 168, and 169. Did you make those annotations to these images?
Yes, sir, that is all my writing, and those correspond to the angles that are shown inside the store with the angle of the camera.
Okay. And also on states 163, this diagram, did you make this diagram while you were out at that scene?
Yes, sir, I did.
And does that diagram accurately depict not all cameras at that store, but the ones that you were asked to go look at?
Yes, sir.
Would it help the jury potentially to be able to at least kind of see this diagram so that it matches up with the pictures and kind of helps them orient themselves as to what cameras and what angles are you looking at?
I believe it would.
Judge, we will re-offer 167, 168, 169, and we will also offer 163.
No objection, Your Honor, to the mentioned exhibits.
All right. So thus states exhibits 163 through 170 inclusive or admitted without objection. Go ahead.
And I can publish you.
You may.
Thank you. All right, let's see your artwork here, detective. Looking at states 163, here is our grocery store, right? And the Washateria and the convenience store, right?
Yes, sir.
Our gas pumps are over here on the left side, and this is Comport right here, right?
Yes, sir.
The cameras that you were asked to look at are the ones that are over here on this left corner.
Yes, sir.
What cameras were over there on that left corner? What camera numbers that correlate to what the clerk would view inside?
2 and 3.
Okay. And then on the back here, I noticed you got camera 11. Was that to kind of help orient and understand exactly where everything is?
Yes. May I stand?
Yes, go for it.
But also, it might help the jury. You've got a still of the video that is on display, and it might help the jury to be able to use the drawing and correlate that to what is being shown on the still of the video of the event that's been admitted into evidence. And that's
State's Exhibit 1.
State's Exhibit 1.
That'll be my next, Judge.
Okay.
So, Detective, just the front parking lot of the SNS grocery. Show us where that is.
This is the front of the store facing Concord. There's parking here, gas pumps here.
Okay, so if we look at the two cameras in states 167, is that left corner that you've annotated cameras 2 and 3 in states 163?
Yes, sir.
Okay, so this is the orientation of those cameras, right?
Yes, sir.
And if we look at states 12 back on August 6, 2023, do they appear to be in the same orientation?
Yes.
You got a different angle that this picture is taken from, but do they appear to be in the same positioning and orientation as they were back then?
Yes, sir.
Now, if we go to the interview, states 165. What does this depict? Now, this is a photo you took, and it's got more than one image, correct? Of camera image, but is that from the inside of the store?
The inside of the store, and I was focused mainly on this image here for camera 2 that faces the gas pumps.
Okay, so this is this essentially what the clerk at the gas station is able to see out these cameras from the clerk's desk?
Yes.
Okay, so the top image on states 165, does that show what camera 2 points towards?
Yes, sir, it does.
And is that pointing towards kind of the back over here? Yes, sir. Okay. Now, what about? Also notice that you had camera 11 marked on this states 163.
Yes, sir.
Looking at states 166, is that the back parking lot of the SNS grocery?
Yes, sir. The back parking lot facing toward the edge of the gas pumps.
Okay, so does it show? Is the back parking lot cameras, camera 11, does it show the area over here where the shooting occurred?
No, sir. Camera 11 is facing.
So if Jeremy Dixon's vehicle was parked right over here, kind of on that fence line, would that have been in view of camera 11?
No, sir.
Now, if we look at find it here. Camera takes 164. That has several, three specifically views, doesn't it?
Yes, sir.
And these are just screens inside that clerk's, behind that clerk's desk, right?
Yes, sir. They have a large flat screen TV that has several cameras at one time for different parts of the store.
Okay. So states 164, if we look at the top, do we see camera 3?
Yes, sir.
Okay, so camera 3, is it looking towards the pumps over here in states 163?
Yes, sir, it is.
Kind of like the pumps and between the pumps and the Concord Road.
Yes, sir.
Now, comparing camera 3 in states 164 to what we're looking at over here in states exhibit 1, would over here is the pumps, right?
Yes, sir.
Oh, there it was. Just in time to take it off what I was doing. I think you turned it back on. There you go. Over here, is this right around in this area? Is that where the entryway that we see on camera 3 viewpoint up on the projector? Is that about where that is?
Yes, sir.
So do you see any farther down Concord Road to the right on Concord Road past the entryway for vehicles into the Shell station?
No, sir.
So this car right here, this red vehicle and the fights that occurred right here, would they be visible from camera 3?
No, sir.
Okay. I mean, we don't see this tree or anything, you know, beyond right around here, do we? On camera 3.
Right.
And so if someone had suggested they knew that this other camera angle would show a fight that had occurred at that red car in States Exhibit 1, that would be wrong.
I would agree with that.
Okay. Also, in States 164, this middle, the what we've been looking at is camera 3, the top picture, right?
Yes, sir.
This middle picture, camera 9, is that the exact same image or exact same viewpoint as States Exhibit 1 here?
Yes, sir. Because I can see the air conditioning unit, the sidewalk. It would be the same thing.
Meaning there's an AC unit right here that's kind of blinded by this light, right?
Yes, sir.
And then also we see over here, there's some blue markings on the sidewalk that are handicap markings, right?
Yes, sir.
And we see those same markers in camera 9 on States 164.
Yes, sir.
Do we know why that is called camera 9 now and it was called camera 4 then?
Don't know. I can only assume that they either added cameras and then changed the numbering up, But I don't know why it now says a different.
What you observed at that grocery store did it appear to be the same equipment as what was being utilized in 2023?
The exterior cameras look identical to the pictures I've seen in the times.
And in fairness, you've been out to this location for a number of different reasons or cases. Is that fair?
Yes.
So is it fair to say you're somewhat familiar with the system they have, the cameras, and just the individuals, the records custodians or business records custodians for those equipment?
Yes, sir.
If they added more cameras on the inside or did anything to readjust what screen a camera would appear on, might that have affected why it's camera 9 back now and camera 4 then?
You very well could have.
But does it appear to be the exact same image?
Yes, sir, it does.
Okay. That's all I have.
Mr. Vasquez.
Thank you, Al. Investigator Turner, how are you?
I'm good. How are you, sir?
Good, thank you. You work for the district attorney's office,
Yes, sir.
and this case was investigated by Beaumont Police Department.
Yes, sir.
And you don't know why they collected, what footage they collected from what camera? You weren't involved in any of that?
No, sir. I was.
Thank you. Pass order.
Anything else?
No, sir.
And is this man excused?
Please.
You are excused, sir. Thank you. Next, please.
Carolyn Lewis. Thanks.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat. Thank you.
Go ahead. Thank you, Judge. Morning, Ms. Carolyn.
Good morning.
Well, tell us your name and what you do.
I am Carolyn Lewis. I work for the Beaumont Police Department's 911 Center. I am now the 911 manager.
Hey, congrats. And how long you been working for Beaumont Police Department?
Since November 9th, 1992.
Okay. You're the most, I'm gonna put it this way. You're the most experienced person at the 911 dispatch center for Beaumont Police Department, aren't you?
Yes, sir. That's correct.
And so the time that you've been at BPD, have you always worked in dispatch?
Yes, sir.
Okay. So you're familiar with the different systems that have evolved over time for how we handle 911 calls in this area.
Yes.
You're familiar with how to find information to answer specific questions about whether 911 calls did or didn't happen, things like that.
Yes, sir.
Last week, did I ask you to look into a couple of specific questions that I had in reference to some 911 calls on August 6, 2023?
Yes, sir.
Okay, so let's get into that. First, did I ask you to look at calls later in the morning? So we're here on a case, and obviously you don't know anything about the facts of this case, right? Other than what I've told you or explained to you.
That's correct.
But we're here for a shooting that happened around 4:20 something in the morning. What was one of the questions I asked you to look into whether or not there were any 911 calls placed later that morning before a suspect was apprehended by a dumpster up on close to Primrose Street.
Yes, that's correct.
And I'm just gonna pull the map up here. This we've been on a break for a week, Miss Carolyn, so most of us have forgotten as much as we can about this. So, Ms. Carolyn, looking at states, what's been admitted as State's Exhibit 112. This being Concord right here, and this being a grocery store on Concord, SNS Grocery, a Shell station.
Yes, sir.
Is that an area working in dispatch that y'all are very familiar with?
Yes, sir.
Get a lot of calls from there, don't we?
Yes, we do.
Now, did I ask you specifically to look into whether or not there were any calls placed from an Exxon Mobil station right here at this corner? At the corner of, I believe, what's that? You know what that street is right there? This is Primrose, right?
Yes, it's Stilton.
I think that's right, yeah. Concord and Stilton, at the corner, was specifically with an address of 3370 Concord Road. Did I ask you to look to see if there were any calls from that location later that morning, say between the hours of 5 a.m. all the way up to when the suspect was apprehended at the dumpster behind it, 8 a.m.?
Yes.
And first of all, how do you do that? How do you know where to look to find that information?
There's a couple of ways that we can look, but one in particular that I feel is easiest is if I have a phone number. We have a software, a system called ECATS, and I can place that phone number into that software, and I can do a date range. So of course I put the date ranges that he asked me to. You put in the date range and you just ask the software to retrieve the information.
Okay. So you have certain parameters that you're able to enter, and all of the information, like say a 911 call comes in from that location, that information is recorded by the operator that receives that call, isn't it?
Correct.
And in fact, isn't it automatically recorded by the system that basically routes these 911 calls?
Yes.
So you actually have quite a bit of data that you can filter or search for to assist in finding, whether someone ever called 911 or not.
Yes.
Can you also filter it by even geographic location?
Yes.
Can you filter it by sometimes even streets?
You can.
Meaning you could look at all calls the night of 8/6/2023 that came from an address on Concord Road.
Yes.
Okay. So this store right here that I pointed you to, is it a store that also is referred to as Supermex?
Yes, sir.
Okay. Had BPD ever received 911 calls from that location before?
Before the day?
Yes, ma'am.
Yes, sir.
And was there a number associated with that location that those 911 calls had come in from before?
Yes, sir.
Okay, so did you pull a record that would give us that number of what from that location where 911 calls had come in from before? Do you have it? Do you have the records to refer to?
Not with me, I don't.
Here, I'm gonna show you. Is this something that you handed to me? I'm not marking this. I'm just gonna ask the witness to refresh. Is this something that you provided to us before you came to testify? Emails and attachments?
Yes, sir. Yes.
Okay, specifically, looking at this record right here, is that the record that I'm asking you about right now?
Yes, it is.
Okay, would it refresh your memory if you were able to refer to this to identify like a phone number or something like that?
Yes.
what was the phone number for the Supermex convenience store that had called into 911 before the date in question?
The phone number was area code 409-835-8844.
And had there actually been a 911 call within the last 30 days from before 8/6/2023? Okay. On August 6, 2023, were there any 911 calls recorded from that location, the Supermex?
August 6th. I don't recall any numbers from the Supermax.
And you know what? I have the other part of this.
Not with this same phone number.
Okay, and that being
The 806.
just to make sure I'm reading this into the record correctly. Where's that sheet? Yes, ma'am. I can see it. I'm sorry. And that being the number that BPD dispatch has associated with the Supermex convenience store at 3370 Concord Road, 409-835-8844. Did we receive any calls from that number or that location on August 6, 2023? Get here.
Not on August 6th.
I'm sorry, ma'am.
Not any on August 6th.
Okay, so if the defendant testified that he asked the clerk of that store to make a phone call to 911, do we have any record to show that that call was ever made?
No.
Okay. Did I also ask you to look to see if there were any 911 hangups, meaning calls that did not come through, they were hung up before the dispatcher ever answered?
Yes.
On that date?
Yes, sir, you did.
And were there any 911 hang-up calls the morning of August 6, 2023?
Not from the 409-835-8844.
Okay, fair enough. Were there other numbers that we did have a 911 hang-up call from?
Yes.
Okay, now, would it refresh your memory to be able to refer to these records that you provided us?
Oh, yes.
Specifically, if we have information that a number attributable to the defendant, in this case, Jeremy Dixon, 409-932-7769. Do we have any 911 hang-up calls from that device on August 6th, 2023?
We don't have any 911 hangups, but we have 911 abandoned calls.
Okay.
Those are two different things.
911 hang up, meaning they actually connect and then hang the phone up and with the dispatcher.
Correct. But on an abandoned call, if you dial 911, or you can dial a series of numbers that may have 9, 1, and 1 in. And you may dial it, it'll dial into dispatch, but it's disconnected before we hang up. So when that happens in the dispatch office, our phone gives a different ring. It gives you like a weird ring. So we know that those are abandoned calls. When those types of calls occur, the dispatcher has to call that number back.
Okay.
Just to make sure that the person doesn't have an emergency.
You get situations where, say, a wife or a woman is in distress and they start to call 911, but they're in the middle of a fight or argument and, someone slaps the phone away or something like that. And it's important to call back.
Yes.
What time did we receive an abandoned call from the number 7769, I believe it is, ending in 7769?
Yes, sir. We received an abandoned call at 4:23:02 a.m.
Okay. And just to be clear too, like if I take my phone out right now and dial 911 and hit send, and then just a few seconds later hit end call, would that be potentially recorded as an abandoned call with the dispatch?
It could, and because we're at the courthouse, it could possibly go to Jefferson County's dispatch office or BPD's dispatch office.
So it knows where I'm at all times if I call it.
So it's gonna get the cell phone, will get the closest tower.
Okay. Now, did we also show a record of our BPD dispatch shortly thereafter attempting to call that number back?
Yes.
Do you know how long after it was that we tried to call back?
I showed one of our dispatch trainees called back at 4:23:21.
So 15 seconds later?
Yes.
Okay. And do you know what specific trainee that was that tried to call back?
Yes, it will show us, every operator logs in with their own user ID and password. So it shows that Jay Baker was the actual call taker that called it back.
So at 4:23, there was an abandoned call from that device.
Yes, sir.
Meaning there was nobody ever talked on the phone.
No, sir.
Okay. And I guess to be fair, we don't know who had that phone when it was called, do we?
That's correct.
Because nobody ever talked.
That's correct.
Okay, so all we know is that from that device, there was an abandoned call at that time.
Yes.
Okay, thank you, ma'am. I don't have any other questions from this here. Mr. Vasquez.
Since November 9th, 1992.
Yes, sir.
How do you like it so far? Tell me, please. Capital E, capital C, little a, capital T, capital S. What is that an acronym for? What does that mean?
It's just ECAS. It's just, that's the name of their software. They're based out of California.
And if I read that ECAS does not, did I say right?
Yep, you said it right.
ECAS does not report on hang-up calls. What does that mean?
Not that they don't report on hang-up calls, there's no report on abandoned calls. Meaning that the call didn't actually connect to our office before dispatch could actually answer. On hang-up calls, if the call had actually gone through and we answered, it would have recorded. That would have been a recorded conversation. Because it would have at least gotten us saying, Beaumont 911, where's your emergency?
Am I correct if I say it reports on abandoned calls and does not report on hang-up calls? Is that a correct statement? Almost?
Almost. It's a little complicated. Because the abandoned call didn't actually make it through, but the hang-up call did make it through. So we could find, if there was an actual hang-up call, we could find, or research it to see if there was actual a hang-up.
I thought it didn't report on hang-up calls.
It doesn't record if it doesn't make it to us. Meaning if I don't pick up the phone, it's not gonna record. There's nothing to record because it didn't connect to our system. It didn't connect to our recorder. It didn't connect to ECATs. There's nothing for it to record. But on the abandoned calls, because it actually reached us, it gives us a funny ring, so we are able to call that phone number back.
Thank you.
Nothing else.
Is this lady excused?
Please.
You are excused. Thank you, ma'am. Next, please.
Judge, can we take a quick break? I gotta show a couple things to my next witness and then we'll be ready to go. He's ready.
All right. 5-10 minute break, ladies and gentlemen. Okay. Relax, stretch your legs outside. Thank you very much. Thank you. Everyone else remain seated while the jury exits first. Thank you. We're in short recess. Thank you. What's the question? Record shall also show now that not only are the parties present, the jury is also present, and the state may continue, and it's redirect.
We call Jason Flores.
Raise your right hand, so you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Have a seat, please. Thank you.
Morning, detective. Morning. Tell us your name and what you do.
Jason Flores. I'm currently employed with Beaumont Police Department, and I'm a detective in the family violence unit.
Okay. Back in 2023, were you a detective in crimes against persons?
Yes, sir.
Okay. What's the difference between those two units?
Crimes against persons usually handles all the calls where people aren't related, strangers, friends, or somebody that commits an assault or a robbery or homicide against someone else. Family violence, we cover just between the family on the adult side.
Okay. Still working as a detective and investigating these crimes, but just from these two different units.
Yes, sir.
How long have you been a detective with Beaumont Police Department?
A little over 4 years, something.
Okay. And do you recall being assigned the lead detective in a case involving the death of an individual by the name of Raymond Whittington?
Yes, sir.
From a homicide that happened back on August 6, 2023?
Yes.
Okay. So how do these investigations typically work in persons? Are you, as the lead detective, tasked with completing every investigative assignment, or talking to every single witness, or do they work in kind of a team as a collaborative?
It's a team effort.
So is it fair to say there were a lot of different moving parts in this investigation, starting from that morning when Beaumont Police arrived at that scene?
Yes.
Were you, for example, were you there when Jeremy Dixon was interviewed?
No, sir.
That was Detective Wilson and Detective Carmouche, right?
Right.
Did you go to the scene though initially, and were you a part of the investigation that was working that scene while other investigators were talking to witnesses?
Yes, sir.
Okay. So, Detective Surratt has testified before you. Did he help work the scene?
Yes, sir.
In fact, I think he set up the Leica total station, and they mapped out that entire scene with all the cones and everything, didn't they?
Yes, sir.
And then Detective Wilson has testified. She went and with Detective Carmouche, and they interviewed Jeremy Dixon as well as Gregory Carrington, right?
Yes, sir.
So I'm not going to ask you a lot about some of the things that they've done. I don't want to duplicate and waste time, okay? But I do want to ask you about some of your observations at the scene. When you arrived, was one of the first things that you did look at the video evidence that officers were working on obtaining?
Yes, sir.
And did you see an individual that we later identified as Jeremy Dixon in that video shooting Raymond Whittington?
Yes, sir.
And do you recognize Jeremy Dixon here in court today?
Yes, sir.
Would you identify him by an article of clothing that he's wearing?
Change that.
Will the record reflect the witnesses identify the defendant?
Yes, it's
So I have one specific question for you, Detective, about the scene. I want to point you to a couple of photos here that have been labeled as so we look at State's Exhibit. State's Exhibit 20. We see Mr. Whittington there on the ground, right?
Yes, sir.
This is that alleyway in the side of the SNS grocery, right?
Yes, sir.
In that back corner, what is this?
That's Mr. Dixon's car.
That vehicle, did we run registration for it and find out who the registered owner was?
Yes, sir.
And who was the registered owner of that vehicle?
Mr. Dixon.
Okay, so it was this defendant here, Jeremy Dixon?
Yes, sir.
And when you walked to the scene and started walking through it and observing, what evidence, might remain from the shooting, did you look around that car?
Yes, sir.
And did you attempt to look inside the windows of that car to see what was in there?
Yes, sir.
Did you try and open the door?
Yes, sir.
Now, at some point, you obtained a search warrant to go inside this vehicle, correct?
Yes, sir. I did.
So after that fact, after you have this search warrant, was there still a reason why you didn't necessarily open the door at the scene?
We were going to send it to the Judge County Crime Lab for them to process.
And why was it, why did you make that decision to send it to the crime lab to process that vehicle?
If I remember correctly, I think there was some blood by the door handle on the driver's side.
Okay.
And since there's obviously DNA there, I didn't want to touch anything. And let the crime lab do that.
Okay, so if we look at State's Exhibit 31, is that a closer image of the car and the area where you saw the blood on the door handle?
Yes, sir.
Okay, now if we go to State's Exhibit 36, is that from the back side of the car?
Yes, sir, it is.
State's 37, is that from the passenger side of the car?
Yes, sir.
And State's 30, that's the driver's side of the car.
Yes, sir, it is.
These cones right here, they're in State's Exhibit 30, are those marking 9mm shell casings that were located?
Yes, sir, I believe so.
Okay. And you said that you saw some possible blood. Is that how you characterize it at the scene? You're not a scientist that makes that determination. So you characterize things as possible blood?
Yes, sir.
You saw some possible blood near the area of the door handle of that car?
Yes, sir.
The driver's side door handle?
Yes, sir.
Okay. Now, later, after detectives speak with Jeremy Dixon, do you more or less ascertain that the likely source of that blood is Jeremy Dixon from when he went towards the car?
Yes.
Okay.
That's what I was thinking.
Yes. But did you also look inside the windows of that car?
Yes, I did.
What did you see anything that was of note when you looked inside those windows?
The only thing I could see when I looked at the front windshield was the tint's pretty dark on it. Down the light through, I could see a set of keys sitting on the driver's seat near the center console.
Let me show you what's marked as State's Exhibit 171. Does that look like the area next to the console inside Jeremy Dixon's vehicle that you observed on August 6th, 2023?
Yes, sir.
Now, you understand this is a picture in full daylight taken by the crime lab, right?
Yes, sir.
But does this appear to be what you saw in low light conditions in Jeremy Dixon's vehicle at the scene?
Yes, sir, it is.
So do you know whether or not the door to Jeremy Dixon's vehicle was locked?
I didn't touch it so much.
And the reason you didn't touch it, is that because of the possible blood on that handle?
Yes, sir.
Okay. But State's 171, does that fairly and accurately depict in daylight settings and what you observed inside the window of Jeremy Dixon's vehicle?
Yes, sir.
Okay. We'll lock for 171.
No objection to State's 171.
Admitted.
You said you thought you saw a set of keys.
Yes, sir.
State's 171. Is that the set of keys you saw?
I believe so. Yes, sir.
Could you really see the color very well in those low light conditions?
No, sir. And I think that center console part was actually closed.
Okay, so the center console part may have been closed and those keys were just sitting right next to it in that, like the seat cushion.
Yes, sir.
Okay. Do those appear to be potentially the keys to that vehicle?
Let's object to the last question is speculative.
What's your objection? Speculative?
Speculation.
Do you know the answer to that?
At the time I saw them, I thought they were possibly the keys to the car.
Okay. Now, of course, you had reason to not pry them out, right? Until you obtain a proper search warrant and let the lab do their work to make sure they're securing any potential evidence from that vehicle, right?
Yes.
But if Jeremy Dixon is now claiming that someone that he was in a fight with before this shooting, that the reason that he kept going back to this location where they were fighting was because that someone had his keys. If those are in fact his keys, does that more or less negate or cut away at his premise for self-defense?
Objection, Your Honor, that's asking the witness to speculate.
Your response?
I asked him hypothetically if those are in fact his keys. I intend to call another witness to establish that.
Okay, all right. Any other objection?
No.
Okay, your objection is overruled. The jury, as in all matters, as you are reviewing the evidence, you get to determine how much weight and credibility should be given to the evidence, to those items and items of evidence based upon the presentation of the testimony and other evidence which may or may not support those matters. You get to decide what the evidence is and how much weight and credibility you will use in your determination on your deliberations in resolving and deliberating upon this case and the indictment elements of this case. Thank you, ladies and gentlemen. Ask your next question.
Do you remember my first question?
You could have repeated.
If those are in fact Jeremy Dixon's keys, and those are the keys to that vehicle, does it more or less cut away at or invalidate his statements that he continued to go back to Raymond Whittington, Jordan Whittington, and all the people in that group and continued to fight because they had his keys?
Judge, objection again, it's a compounded question and speculative.
Overrule, you may answer.
I would say it hurts him big time. If that's his whole basis was claiming he couldn't leave, he had the keys. Keys are sitting right there.
Object to the answer, Your Honor, is non-responsive.
Overruled. Go ahead.
Now, because there's two camera views or videos that you and other detectives kind of honed in on in this case, right?
Yes, sir.
One being that of the front parking lot, and then one being that of the side alleyway where the shooting actually happened.
Yes, sir.
Now, the view from the front parking lot, that shows fighting between Jeremy Dixon and several other individuals, a few minutes, say 15 minutes before the actual shooting.
Yes, sir.
And we'll just go ahead and go through that. I'm showing you what's been admitted as State's Exhibit 1. We're going detective to camera A4. And we're looking at the last file in that camera folder. File name ending in _001. Now, detective, did I also ask you to look at whether or not adjusting any of the video settings, the video playback settings, when playing this video file, if that would help make the video clearer or help maybe see more defined people farther in the background?
Yes, sir, you did.
And did we look at adjusting the contrast and brightness a little bit in that video playback settings and see what differences we could see as far as the people in the far front end of the parking lot.
Yes, sir.
Does adjusting the contrast and the brightness slightly illuminate a lot of the activities we see up here by this red car right next to the street?
Yes, sir, it did.
Okay. Does it also make it so that you can barely see anything on the sidewalk right here?
Yes, sir.
Sorry. Let me, yeah, it's a pretty big difference if you set the contrast back, isn't it?
Yes, sir.
But initially, do we see Jeremy Dixon appear here on this sidewalk?
Yes, we do.
You see that person right there? Does he have a assault rifle on his shoulder?
Looks like it though. He does.
I'm just gonna pull up your attention to the very first time that we see Jeremy Dixon on that sidewalk. I think we're getting close to it here. All right, so we that's at 3:54 in the morning. Does that appear back right there to be what we eventually see as Jeremy Dixon?
Yes, sir.
Recognize him with those jean shorts and the shoes that have the different color soles.
Yes, sir.
Now, you see how he's kind of looking out towards the parking lot there?
Yes, sir.
Do we notice that he does that several times?
Yes, you do. As you watch it.
And if we go out here, in the general direction that he's looking, is that the vehicle of a Crystal Thomas and Raymond Whittington?
Yes, sir.
And so we see a lot of the actors that are involved in this initial assault and then later witness to Jeremy Dixon shooting Raymond Whittington. That being Jordan Whittington, Crystal Thomas, and Octavia Charles.
Yes, sir.
see something to change it. Back it up a little bit here. See, you see this person right here?
Yes, sir.
He talks to Jeremy in a minute, doesn't he?
Yes, sir.
Does that person look like he's carrying a gun?
He's closer, I don't think you can tell.
Isn't that what that looks like right there? The way his hand is placed and the kind of shiny object underneath it?
The way he's holding it as well.
You notice how they're both looking over in that direction.
Yes, sir.
And that would be at 3:55 a.m. and 24 seconds. All right.
Yes, sir.
Now we spent some time over here, Jeremy does, where he's just kind of in this group talking to other people, doesn't he?
Yes, sir.
Fast forward a little bit here. All right, I lost him, but it looked like he moved right over here.
The lady comes walking back here.
Yeah, do you see those? You see those shoes?
Yes.
And shorts? And are there two women sitting on the, or at least one woman sitting on the back of the trunk of that car right there that he looks like he might be talking to?
Yes, sir.
See this person right here.
Yes, sir.
Do we later see that person go back over towards where Raymond Whittington is?
Yes, it does.
Does it look like Jeremy Dixon, although he still could be talking to these people, does it also look like he might be looking over in that direction of where Raymond Whittington is?
Objection, Your Honor, speculation.
Based on what he sees in the video.
All right, your objection is speculation?
Yes, sir.
Question, does it look like Jeremy Dixon, although he still could be talking to these people, does it look like he might be looking over in the direction of where Raymond Whittington is? Can you answer that question?
Yes, sir. I can.
All right. Overruled, you may answer it, and the jury gets to determine how much weight and credibility give it in the way the question is asked, as might he be looking over in that direction? Overruled, you answer?
Yes, sir. After watching him, you do what appears to me, it looks like he's looking over in that direction several times while he's sitting over there by the car.
Meaning if he were talking to someone who was sitting on the trunk of a car right here next to him, he would essentially just kind of be gazing a little bit off to the right and turning his head just a little bit, and he would be looking directly towards where Raymond Whittington is.
That's what it looks like to me, yes, sir.
There, at 4 a.m. exactly, in 32 seconds, they're still at that car talking, aren't they?
Yes, sir.
Being Jeremy Dixon and those other two people.
There's not an answer to that last question.
Yes, sir, I see it.
It says being Jeremy Dixon and those other two people.
Yes, sir.
Thank you.
Like, for example, where he's right here at 4:01 a.m. and 7 seconds. We kind of see him at a little bit of an angle where it looks like he might not be totally looking at the people that are directly in front of him.
Correct. I can't tell.
Object to speculation.
Is that correct?
Yeah, I can tell. I'm sorry.
Objection is overruled. He can answer it. And again, the jury gets to determine how much weight and credibility to be given. The evidence in the way it's questioned is provided and the answer given. Overruled. Go ahead.
I can't tell from that.
It's pretty hard when the more you zoom in, the grainier it gets, isn't it?
Yes, sir.
Okay. Okay. So now do we see that person in the shorts hop off the back of that car and start walking over towards Raymond Whittington?
Yes, sir.
And then do we see Jeremy Dixon following behind?
He's right there in front of me, sir.
Now, is Jeremy Dixon now clearly looking over in that direction?
It appears with his head direction, he's looking over there.
Now, see how his hand is right over his pocket right there?
Yes, sir.
If someone is wearing shorts, baggy shorts, is that typically something they might do if they were carrying something heavy in one particular pocket?
Yes, sir. They try to keep their shorts pulled up.
So like a gun.
Possibly.
Would that, people walk like that with a gun sometimes,
Yes.
if they're needing to keep their shorts up?
Yes, sir. They do.
Do we actually see several people doing something similar, just on this video alone?
Yes, sir.
Now, to be fair, did you and other investigators have, I guess, two different theories about how and when Jeremy Dixon got that gun?
Yes, sir. Right. I do.
What were your two theories?
Either he had the gun on the entire time, even when they fought at the house next door, or when he went back to his car, he grabbed it.
Because in his interview with Detective Wilson, did Jeremy Dixon say that he went back to his car?
Yes, sir. He did.
Okay. You notice how, I'm backing it up there. We're looking at, 4:02 a.m. and 20 seconds. You notice how he's kind of like fidgeting with something in his pocket. You see that?
It does look like he grabbed something on the side there.
Now, do we see that guy with the shorts over here?
Yes, sir.
Okay, so let me adjust this contrast back. if you put the contrast at 0 versus if you raise the contrast of the video playback to say 60 or 70, does that make a huge difference in what you could see in these dark areas of this parking lot?
Yes, sir. It improves it.
Okay, so just in general, Jeremy Dixon is over here walking towards Raymond Whittington and all these people are here, right?
Yes, sir.
This person in the shorts is talking to an individual with no shirt on right here. We know that. Do we know that person with no shirt on right now to be Jordan Whittington?
Yes, sir.
Okay. This taller individual with the shirt on, and you'll eventually see some light colored Timberland boots. Do we know that person to be who or Raymond Whittington?
Yes, sir.
On the hood of this car right here, we see this woman. Do we know that person to be Octavia Charles?
Yes, sir.
Over farther to the right on the hood of this car, we see another one. Do we know that person to be a Crystal Thomas?
Yes, sir.
And I will represent to you, based on what other witnesses have identified, including Jeremy Dixon and a Crystal Thomas, that this person right here, this little guy in the blue jeans and the white shirt, that is a cousin to Raymond by the name of Chucky. That's all we know him as.
Right.
You didn't know that during your investigation. You never had identified that person.
No, sir, I didn't.
But he appears in different spots in these videos, doesn't he?
Correct.
Also, Detective, the individual in this car, did we ever identify who that was?
No, sir.
I'll represent to you that Mr. Dixon testified that the person in that car was an individual by the name of Riley Barnes. And that he was going to talk to Riley Barnes. That's why he went over there. As we see him.
Hold on, help the jury here. And I know they're following me along. Be careful when you use pronouns he or she. There's a lot of he's and she's in all these images. Please be descriptive and identify to help the jury understand the pronouns from their general meaning to an accurate identification. Thank you.
Let me tell you my question to this. As Jeremy Dixon is approaching this group, does he ever go towards that car and actually talk to Riley Barnes?
I've never seen him talk to him. He got close to it, but I've never seen him walk up to the door, actually.
So when he first approaches this group, does he go towards essentially where Octavia Charles is first?
I believe so. More correct.
See how do you see how he kind of gets in between, right next to Octavia, and actually gets in between Raymond Whittington and Octavia?
Yes, sir.
Is that Raymond Whittington or Pooh? Is that Pooh directly behind him right there?
Yes, sir.
And is Pooh talking to that other guy in the shorts that had come over just before Jeremy Dixon?
It appears to be, yes, sir.
See that right there? Did you see what hit that movement that we just saw right there?
Like you might have touched them on.
Yeah, let me back that up. What do we see Jeremy Dixon do right here in just a second?
It's looking, it looks like he touched, Mr. Whittington on the shoulder area there.
Kind of, does it look like he kind of extended his left arm and kind of touched Raymond Whittington on the chest somewhere?
It looks like it, yes, sir.
And I said extended left arm, didn't I?
Yes, sir.
Extend his left. Does he do it again there, right there?
It appears he did.
Was he doing it again right there?
Yes, you see his hand come up and so on.
Again, right there.
Yes, sir.
And for the record, are we at 4:03 a.m. and 29 seconds?
Yes, sir.
Now, Jeremy Dixon, does he actually kind of turn Raymond Whittington and force him to face Jeremy Dixon directly?
Play that again?
Yes, sir. Back it up. See the hand?
Yes, sir.
See the hand again?
Yes, sir.
See the hand again?
Yes, sir.
Now, right there, see that? What do we see right there?
Looks like he pulled him hard enough to turn him around.
I'm sorry, just to pronoun, just ask the witness to use names. I missed that.
I'll clarify, Judge.
Okay, thank you. Sustain. Go ahead.
Do we see there Jeremy Dixon actually kind of pull Pooh or Raymond Whittington, either turn him a little bit or kind of push him to the back so that they are facing each other?
Yes, sir.
And do we see Jeremy Dixon? He actually turns to counterclockwise, doesn't he? And turns to face Raymond Whittington, doesn't he?
Yes, sir.
Oh. Back it up just so you can see it one more time. Now, that movement that Raymond Whittington is doing there, it's kind of unusual, isn't it? He's what's he doing? Does it look like?
Looks like he's actually trying to face the away from Mr. Dixon.
He's kind of bent over, isn't he?
He looks hunched over, sir.
Like kind of like an avoidant position, right? Is that what that kind of looks like?
Check the leading, Your Honor.
Go ahead. Sustain.
Does that position or does that body language from Raymond Whittington look like he's trying to avoid Jeremy Dixon?
It doesn't look like he's trying to engage with it.
Fair enough. All right, so there is where he turns. And now it's Jeremy Dixon walking towards Raymond Whittington and essentially walking him backwards.
It appears so, yes, sir.
Has Jeremy Dixon, at this point, isolated Raymond Whittington from everyone else in the group?
It looks like he has him, Mr. Whittington's back up against that car right there and he's face to face with him.
Okay. Now, do we start to see a change in Mr. Whittington's demeanor, Raymond Whittington's demeanor?
Yes, sir.
Does he seem to get more hostile or aggressive in the conversation that he is having with Jeremy Dixon?
It appears right there he does.
And do we see Jeremy Dixon put his hand again on Raymond Whittington's chest, and then Raymond Whittington pushed him back?
It appears so.
And is that at 4:04 a.m. and 6 seconds?
Yes, sir.
Is Jeremy Dixon putting his hand again on Raymond Whittington's chest?
Yes, sir.
Now we see Jeremy Dixon turn towards Jordan Whittington, who's standing right here.
Yes, sir.
And then do we see Raymond Whittington coming behind Jeremy Dixon? Or right there.
Right there, yes, sir.
Is Raymond Whittington in kind of a very aggressive stance right there in this shot?
It seems like his demeanor is more aggressive right there.
And it's essentially looking directly at Jeremy Dixon from the side, right?
It appears so, yes, sir.
And would that be at 4:04 a.m. 55 seconds?
Yes, sir.
So just so we know where everyone is here, we're at some 4:05 a.m. That's Jordan Whittington, right?
Yes, sir.
Jeremy Dixon is right to his left.
Yes, sir.
That's the individual people have identified as Chucky.
Yes, sir.
That's Raymond Whittington right here.
Yes, sir.
Octavia Charles is sitting right here.
Yes, sir.
And Crystal Thomas is now at the driver's side door of that vehicle.
Yes, sir.
And we don't know who these people are, do we?
No, sir.
Now, do Jeremy Dixon and Raymond Whittington look like they're both kind of getting confrontational with each other?
It appears so, yes, sir.
And then we see Raymond Whittington set his bottle down, his drink down on the hood of that car.
Yes, sir.
And would that be 4:05 a.m., 53 seconds?
Yes, sir.
And does he go back to basically being very close face to face with Jeremy Dixon?
Yes, sir, he does.
Now, do you see everyone in this group, this argument is still going? You see everyone in this group is now has their attention on those two, Jeremy Dixon and Raymond Whittington.
Yes, sir.
Before, when Jeremy Dixon first went over there, was everyone still focused on their individual conversations or whatever it is they were doing or talking about?
You look like that, yes, sir.
But now, does it appear as though everyone is now focusing on this conflict?
Yes, sir, it does.
Now, if I'm gonna rewind this a little bit, is this right at 4:07 a.m. and 14 seconds?
Yes, sir.
Is that the first time we see Jeremy Dixon kind of look over towards the vehicle occupied by, he claims, Riley Barnes, and actually like have some sort of body language suggestion he's communicating with Riley Barnes? Watch this. Does he see how he's kind of looking off to the right there?
Yes, sir.
Is that the first time we really see any form of communication between the two of those?
Up to this point, that's the first time I can see him. Looks like he's directing his attention to that car.
And at this point, is Raymond Whittington now directing his attention back towards where Octavia Charles is and Crystal Thomas is?
Yes, sir.
Now, if we get to this timestamp right here, which is 4:07 a.m. and 44 seconds. We see Jeremy Dixon is essentially standing by himself in this group of people.
Yes, sir.
No one's talking to them, are they?
Not at that point, sir.
Where's Raymond Whittington now?
On the other side of this vehicle.
Kind of by the driver's side door?
That front forward panel, yes, sir.
Did Raymond Whittington go and back and get his bottle that he had?
Looks like he does.
Now where is Raymond Whittington?
The back of his vehicle.
And what's he doing?
Like he's taking a sip of his drink, facing the street.
Is he sitting on the trunk?
Looks like it, yes, sir.
Is he by himself?
Yes, sir.
All right, so we are now at 4:09 AM and 8 seconds. Does Raymond Whittington now jump off that trunk of his vehicle and start to walk back around?
Yes, sir.
Now, when he does that, what do we see right here?
Walking over there. Mr. Dixon.
He walks right by Jeremy Dixon, doesn't he?
Yes, sir.
And what does Jeremy Dixon do?
Like he has a left arm out.
Does he kind of extend his arm to make sure that he has some sort of physical contact with Raymond Whittington?
It appears so, yes, sir.
Back it up. See that? And does he appear to then reinitiate talking back and forth with Raymond Whittington?
Yes, it looks like that.
Are Brandon Whittington and Jordan Whittington now at the driver's side window of that car supposedly occupied by Robin Barnes?
Yes, sir.
Now, does Jeremy Dixon leave the front of the vehicle where Octavia and Crystal are, and then go over to the area where Raymond and Jordan are again?
Yes, sir.
Does it like they're like everybody's seeing somebody or waving at somebody?
No, it's like Mr. Dixon might have pulled him or something.
Now, does Raymond Whittington appear to be getting more and more confrontational?
Looks like he is.
And based on what we've seen Jeremy Dixon do, is he appear to be reciprocating that argumentative confrontational stance?
It looks like they're both standing there possibly arguing with each other.
Do we also see Octavia Charles stand up and walk away right before Raymond Whittington hits Jeremy Dixon?
Yes, sir, sure.
All right, now this is right here at 4:10 AM and 25 seconds. Is that right at the moment where Raymond Whittington takes a swing, the first swing at Jeremy Dixon?
Yes, sir.
Now, what do we see right after this? Let's watch. All right, so after Raymond Whittington takes that first swing, do we see Jeremy Dixon react?
Looks like he's trying to shove Mr. Whittington off to the R left up there, towards the front of that car.
Does Jeremy Dixon clearly make contact with Raymond Whittington almost immediately after Raymond Whittington takes that swing?
Yes, sir, it looks like.
Does Jeremy Dixon then lunge at Raymond Whittington and push him into Riley Barnes's car?
Yes, sir.
Does it appear right here that Jeremy Dixon is swinging and hitting Raymond Whittington?
He played for him.
Yes.
They're definitely fighting each other.
Let me back it up for you. One more time. Now, obviously, Raymond Whittington is still swinging at Jeremy Dixon, right?
Yes, sir.
Does Jeremy Dixon appear to be swinging and hitting Raymond Whittington as well?
Hold on for just a second. Don't be doing that. I'm talking to you. Don't be shaking your head or nodding your head. That is clearly an attempt to try to influence the jury. I'm watching you, sir. Stay stoic. Do you understand?
So,
You don't be responding to, you're not to respond to his questions or his answers. I've instructed you to follow the rules. Are you able to do that or not? You will be punished next time you attempt to try to influence the jury. Don't be doing that. That's the only reason you could be doing that. It's not your time to speak. You can speak to your attorney, but you don't nod your head in response to questions or shake your head. That can only be perceived as attempting to try to influence the jury. Follow the rules, sir. Proceed.
Yes. Raymond Whittington and Jeremy Dixon, do they both appear to be hitting each other?
yes, sir. It looks like they're fighting each other.
Jeremy Dixon is significantly bigger than Raymond Whittington, isn't he?
Yes, sir.
So if Jordan Whittington said when he testified that he saw his brother fighting with someone who was a lot bigger than him, and that is why he joined and started hitting Jeremy Dixon as well, does this video support that?
Yes, sir.
Now they get Jeremy Dixon on the ground, don't they?
Yes, sir.
And they're hitting him on the ground, aren't they?
Yes, sir.
And they being Raymond Whittington and Jordan Whittington.
Yes, sir.
Now, both of those, Raymond and Jordan, they get a few hits, but they do stop, don't they?
Yes, sir.
At 4:10 a.m. and 46 seconds, do we see Jordan kind of step back?
Yes, sir.
And is Raymond still hitting Jeremy?
Yes, he did.
Now, is there a series here after 4:10 a.m. where Raymond Whittington and Jeremy Dixon are both kind of wrapped up in each other on the passenger side of Raymond Whittington's car?
Yes, sir.
Is Jordan Whittington hitting Jeremy Dixon at all?
No, sir. It was in a period.
All right, you see that? You see what Jordan Whittington does right there? Throws something. Where it lands right there.
Yes, sir.
So one of the contentions that Jeremy Dixon has made is that his keys were lost somewhere in this scuffle.
Yes, sir. You made it.
Now, we believe that his keys are right here in his car, State's Exhibit 171.
Yes, sir.
Jeremy Dixon believes, based on his testimony, that little Chucky goes and picks up his keys. Do we see Chucky come and pick something up here in a minute?
Play it out.
I don't know if I've even shown you this, but let's watch. But did we see Jordan Whittington throw something right there?
It appeared he did.
Did it look like Jordan Whittington threw his shirt?
It looked like it was a black object, but
Okay.
his t-shirt was black.
Definitely not like a set of keys or anything.
Yeah, that'd be too small.
Let me back up for you just a little more time. Watch what he throws. See that?
That's not keys.
Okay. And for the record, we are at 4:11 a.m. and 30 seconds. So you see a little Chucky right there picking something up?
Yes, sir.
He drops it though, doesn't he? And he picks it up again.
Yes, sir.
Okay, rewind that scene. See, then he picks it up, he drops it, doesn't he?
Yes, sir. Looks like it.
Chucky's pretty easy to spot because he's so little. Isn't he?
Yes, sir.
All right, so let me rewind and we can focus on Raymond and Jordan again. All right, so right there, do we see, I'm sorry, Raymond and Jeremy. Do we see Raymond Whittington push Jeremy Dixon away?
Yes, sir.
And what do we see Jeremy Dixon do?
Open up his pants, his shorts.
And what direction is he headed or walking?
Looks like to the left over there.
And now is that Raymond Whittington going back up to him right there, Jeremy Dixon, right there at the curtain?
Yes, sir.
Are they fighting right now?
No, sir.
And what does Raymond Whittington do? Does he walk away?
Yes, sir.
And what's Jeremy Dixon doing? Is he walking towards Raymond Whittington or towards Raymond Whittington's car, or is he walking away?
Can you play a little bit more? I'm sorry.
Back it up.
He's just hanging out right there by the sidewalk.
Now does it appear Jeremy Dixon is talking to Jordan Whittington?
Looks like it, yes, sir.
And Jordan Whittington is kind of going back and forth with him now, isn't he?
Yes, sir.
All right, I want to pull your attention to this Dodge Durango that just pulled up. You see an individual walking up right beside it. We recognize that person, or eventually are we able to determine that person is Gregory Carrington?
Yes, sir.
Okay, so let's back up to when that Dodge Durango first appears. Okay, so I've that right over here at 4:11 a.m. and 56 seconds. Is that the Dodge Durango pulling into the parking lot of the SNS grocery?
Yes, sir, it is.
And do we see around the back side of that Dodge Durango an individual in kind of a dark shirt walking around?
We will, yes, sir. Right there.
Do we later determine that this is in fact Gregory Carrington?
Yes, sir, it is.
Okay. Did it also appear that he got out of that Dodge Durango?
Yes, sir.
Okay. So at this point, we have Jeremy Dixon right here, right?
Yes, sir.
Gregory Carrington is walking over towards Raymond Whittington.
Yes, sir.
And Jordan Whittington is right here, kind of hidden by the Dodge Durango.
Yes, sir.
And Jeremy Dixon, does he appear to be arguing back and forth with Jordan Whittington?
I don't think so.
Let me see, let me back it up here. You see his body language right there?
Yeah, he's talking to me.
Okay. And then we see Gregory Carrington and Raymond Whittington kind of have this exchange, don't they?
Yes, sir.
But if we go back over here, do things look like they're kind of escalating between Jordan Whittington and Jeremy Dixon?
They're talking, they're close to each other.
And as soon as it looks like, let me back it up here, as soon as it looks like Jordan Whittington